Mr. Godfred Yabua Dami, on behalf of the committee, I congratulate you on your nomination as the Attorney General. It's an elevation. In the last dispensation, you were a deputy. Now you've been made the substantive, nominated as the substantive Attorney General. We vetted you once before. If some things have changed, we would like to hear them. But otherwise, tell us very briefly about yourself. Kindly speak to the mic. Press the button. Yes.
Thank you very much, Mr. Chairman. My name is Godfred Yabwadame. I was born on 5th June 1979. I hail from Wenchi, the Browns region. I had my primary education at Cape Coast at Versailles Memorial Preparatory School. I had only 1 year of my primary education at Commander College Party School. I proceeded to Adisade College to pursue my ordinary level and advanced level certificates. I completed the O level in 94, A level in 96, and I proceeded to the University of Ghana to pursue my Bachelor of Laws degree from 1998 to 2001. In fact, before then, I had done my national service at the KEA district. After the national service, there was 1 year of strike, and for that matter, I had to engage in people teaching at a village called Brasi, also in the KEA district. So after 2001, I went to Ghana Law School, October 2001, completed in 2003 with a professional law certificate. Mr. Chairman, I pursued my national service in this honorable house, completed it in May or June 2004. I did my pupillage at Ekufuado Pempenko concurrently from October 2003 to 2004 June. I continued with my professional law practice at Ekufuado Pempenko. Indeed, I was there apart from 2006, where I had to pursue a course at Oxford University programming comparative media law and policy. I returned to pursue my to carry on with my law practice at Ekufuado Pempenko. I was engaged in private law practice until March 2017, when I was nominated by 2017, I was nominated by the President as Deputy Attorney General and Deputy Minister for Justice. I was approved by this Honorable House, and I was sworn into office on 12th April 2017, and I stayed in that office until 6th January 2021. I was, by the grace of God, nominated again by the President, this time for the office for which I'm being vetted this morning. I'm a Christian. I worship regularly at the Legon Denominational Church. I'm married to Dr. Jocelyn Asimen Dami. We have 2 children. Thank you very much.
Enough members, you may now ask. Yes.
Thank you very much, Mr. Chairman. I'd like to congratulate my good friend, Honorable Godfred Dami, on his appointment. I take note of the fact that by virtue of the date of birth, you're likely to be one of the youngest Attorney General, if not the youngest. I think it's a significant, occurrence that one must take into cognizance, having regard to the fact that the legal profession, is one that deals with a lot of experience and age. That minded by Article 79 of the 1992 Constitution, as I want to premise all my questions, with this in mind, which states, Mr. Chairman, with your indulgence, I will read. The President may, in consultation with the Minister of State and with the prior approval of Parliament, appoint one or more deputy ministers to assist the minister in the performance of his function. My emphasis is on the assist. Now, that notwithstanding, I would like to find out a few things about you to the extent that you were involved to assist. Then you can answer these questions for me. or for the committee. The former special prosecutor, in his report on the Ejapa transaction, made reference to the mandate agreement, and he raised a few issues, one of which is the lack of capacity of the former Deputy Minister for Finance to execute the agreement, and two, that the agreement should be one of the agreements that comes under Article 1815, that also requires prior parliamentary approval, as well as the approval of the Public Procurement Authority. Now, do you share that view of the special prosecutor?
Chairman, thank you very much for the question. Indeed, the special prosecutor,
the former special
prosecutor, but indeed by mentioning special prosecutor, I was referring to the office of the person. So, carried out what he termed risk analysis of the risk of corruption and anti-corruption assessment of the processes leading up to the request for approval and approval of the transaction agreements and tax exemptions granted thereunder in relation to the gold royalties monetization transaction and the Minerals Income Investment Fund Act 2018 at 978, and other related matters thereto. The Chairman, I quoted the full title of the work because the context in which the exercise was carried out must be made clear. Indeed, the special prosecutor indicated that he was acting in line with what he described as risk assessment. And it is worthy to indicate that in Act 959, the Special Office of the Special Prosecutor Act, explicitly, the exercise described as risk analysis or assessment of corruption risk is not indicated. The only clue a person may have as to the set of functions that the Office of Special Prosecutor has been given by Act 959. And a clue whether it includes risk analysis is with regards to Section 2 of the Act. And in Section 2 of the Act, with permission of the Chairman, if I may quote, said the object of the office is to A, investigate and prosecute specific cases of alleged or suspected corruption and corruption-related offenses. B, recover the process of corruption and corruption-related offenses. And C, take steps to prevent corruption. Indeed, it is pertinent to indicate that it is this C that the Office of Special Prosecutor indicated to the public that he was proceeding under. So he considered the conduct of corruption risk assessment as part of the preventive mechanisms that he could deploy to curb corruption. Even though it becomes a matter of interpretation, whether indeed taking steps to prevent corruption can include the conduct of such an exercise. I think that I would be liberal enough to say, fair enough, it could perhaps have come under this provision, even though I've indicated that yes, it's debatable and it's questionable. But the problem, fundamental problem that one may have is that even though Mr. Amidu indicated that he was conducting risk assessment, which of course will entail examination of a specific transaction and its future hazards that transaction may represent. Upon the presentation of that report, of course, he did not owe a duty at all to present the report to the President. I did not see anywhere in Act 959 that mandates the Special Prosecutor to present a copy of the report to the President. But that's the step he took. He presented a copy of the report to the President. And in doing so, he himself spelled out the rationale for doing so. The rationale for presenting a copy of the report was indicated by the Special Prosecutor in his letter to the President, dated 16th October 2020, as informed by the fact that whatever he did was supposed to guide future actions.
Chairman, just, sorry, Minister nominee, just hold your breath there. I'm indulging the chairman. You are saying that the special prosecutor was not required to present the report to who?
To the President.
To the President.
To the President.
He was not required.
It was not required.
Are you aware whether there was a referral from the President to the office of the special prosecutor? You have any indication?
I'm not aware.
You are not aware?
He indicated in his letter that he was carrying out the exercise of his mandate under Section 2, Paragraph C of Act 959. So that is the record.
But you are aware that the special prosecutor, if you read the act that you referred to, was independent on any matter.
Yes.
He could institute an investigation for the purposes of the general good of the country. Do you agree with that?
I agree, and that's not the
Okay, you can continue. Thank you.
Mr. Chairman, and it's actually in line with that I say that he was not obliged to present a corporate report to the President. But he indicated in the report that he presented to the President that he was doing so because the exercise that he was carrying out was only supposed to guide future executive actions of government. And for that matter, he did so. Now, the little fundamental issue I have is that if a report of this nature is prepared and is supposed to guide future executive actions of government, and same is presented to the President, and then upon the perusal of the report, there's no indication of a grant of a hearing to certain public officers whose conduct
Honorable
was
Attorney General nominee, was any of the people mentioned in the report contacted? Was any of the people mentioned in the report contacted? Or the actors in the processes contacted according to the report?
Sure. So the Minister of Finance was indicated. There was also reference to the Minister for Finance in the report. The point I'm making is that even though those persons were not given a hearing from the report, and the Special Prosecutor has indicated that that report was supposed to guide future executive actions of the President. When the report was given to the President, of course, in accordance with the requirements of Article 296, which enjoins a public officer to act reasonably, requested the officer in question, that is the Special Prosecutor, to grant the affected public officers a hearing. Then, surprisingly, the Special Prosecutor construed that request of a hearing to be an interference in his work, and so he resigned. That's my first point. Now, to address
Chairman, so he resigned. Are you attributing his resignation to that? Because
yes,
there is a formal correspondence on his resignation.
Yes, there is.
Are you attributing his resignation of the Special Prosecutor, Martin Alambert Alamis Amidu, to what? I just want to hear you for the record.
Mr. Chairman,
when you say then he resigns, what are you implying?
Right. Mr. Chairman, he indicated clearly in the letter of resignation that he was resigning on account of the request of the President to, as it were, contact the Minister of Finance to be given a hearing. So it is the letter dated 16 November 2020, by which the Special Prosecutor resigned.
And it's further, Chairman, your indulgence, it's further your submission that the Special Prosecutor did not hear persons affected by his report. Is that your submission to this House?
Mr. Chairman, that is so, apart from the request for documents that he had made of the Minister of Finance. So that is, I think, the unfortunate circumstance that characterized the work of the Special Prosecutor. Now, to specifically address the question asked by the Honorable Member, whether I agree with the finding of the Special Prosecutor that the Deputy Minister for Finance, then, such as Dubai, did not have capacity to execute the mandate agreement, I respectfully disagree. I disagree because the capacity to execute a financial agreement has been indicated in the Public Financial Management Act. In there, we find that, Mr. Chairman, the capacity is given to the Minister for Finance or any person that the Minister for Finance may authorize. And in this regard, I may refer to Section 5. I'm sorry. Mr. Chairman, may I just to be right. So Section 5 of the Public Financial Management Act indicates clearly that a person with the capacity to sign agreements under the Act rests in the Minister for Finance, or any person not below the rank of a director that the Minister will authorize. In the light of this, it becomes quite clear that the Deputy Minister for Finance, if he was authorized by the Minister for Finance, had full capacity to execute.
Chairman, just another, we are listening to you keenly.
Honorable committee member, you are not permitted to do that.
We appreciate your reference. You are entitled to your view. Capacity of a minister, yes, and capacity of a deputy minister, and capacity of persons identified in the Public Financial Management Act, as you have referred to, so yes, continue. I'm putting it in context.
Right.
So, within the meaning of Article 78 and 79 of the 1992 Constitution, the capacity of a minister, yes, the capacity of a deputy minister, and those that you have just referred to, but continue.
Right. Gentleman, I'm very grateful for the allusion to Section 79, Article 79, Clause 1 of the Constitution, because indeed that clearly will buttress the point that the Deputy Minister for Finance, if he had been authorized by the Minister for Finance to undertake a special function, then the Deputy Minister for Finance was duly authorized, because the functions of a Deputy Minister, as set out in Article 79, Clause 1, is to assist a minister in the performance of his functions. That is not in doubt. Then Section 5, subsection 1, paragraph C of the Public Financial Management Act, at 921, stipulates as follows. Pursuant to Section 4, the minister may, C, acting on the advice of the Attorney General and subject to the approval of Parliament, enter into and execute an agreement on behalf of the government in relation to matters of a financial nature. So primarily, the capacity to execute any agreement on behalf of the government of Ghana in relation to matters of financial nature rests in the Minister for Finance. Now, the provision goes ahead to stipulate in subsection 2 that the minister may delegate any of the responsibilities under subsection 1 to the chief director or to a senior public officer not below the rank of a director within the ministry, but shall not relieve the ultimate responsibility for performance of the delegated responsibility. That it is not in doubt that a deputy minister is definitely above the rank of a director. And therefore, if a function under Section 5, which is to execute any agreement of financial nature, has been so delegated, I think that delegation is proper. Further, in terms of execution of contracts, financial contracts, state contracts, there is also what we call the State Property and Contracts Act. The State Property and Contracts Act also authorizes the minister in respect of a special subject matter or a person that the minister may delegate that function to
Chairman, just for my record, quote the act number and then the year. Execution of contracts, what you are referring to for our purposes, Chairman.
Chairman, the State Property and Contracts Act
of
19. Chairman, is CA6, 1960. CA6 is an old law, and it stipulates in Section 2 as follows.
Just read the rendition full for me. CA6.
State Property,
yes,
and Contract Act.
Okay, thank you.
1960, CA6. It's an old law. So the point that is being made is that even before the enactment of Act 921, authorization to execute government contracts is set out in law. And that authorization in section 20 of CA6 goes as follows. It says the minister responsible for a subject or department, any other person authorized by the minister, may execute a contract for and on behalf of the Republic on a matter falling within the minister's portfolio. So the operative words here are the minister responsible for a subject or a department or any other person.
I think you're spoken
authorized
to
by
this
the minister.
matter.
So I believe that finding, with all respect, it's not entirely accurate. That's my humble opinion. And indeed, I may also add that the special prosecutor, in the work that he did, essentially was expressing an opinion on a contract, part of which has been approved by this honorable house.
Thank you. So if you are expressing an opinion, what are you doing now? What are you doing now?
What am I doing now?
Yes.
That's why I'm expressing an opinion on his opinion.
Thank you.
Based on the questions that have been asked by the honorable member.
Yes.
Your mic.
Thank you very much, Mr. Chairman. Now, some have held the view that the position taken by the former Attorney General, your immediate past boss, is that of one that is against the transaction. Are you able to confirm whether that is the position?
Opinion is one that's what? Against the transaction. Mr. Chairman, I think that may be respectfully a little bit of an erroneous view to take. I say so because the Attorney General's opinion on the matter, as far as I'm concerned, is the final one given on the matter. Now, there were a series of transactions, and I think that must also place on record that in terms of actual work on the Japan transaction, I was not part of it. I was not part of it because of the schedule of work at the Attorney General's Department. Work is assigned by the minister, as the Honorable Minority Leader indicated. The Deputy Minister says the minister and work is assigned and that kind of thing. But even though I was not part of it, I've had the opportunity of examining the series of Attorney General's opinions delivered on the transaction. And I would say that the first one that came to my attention was the one dated 1st April 2019. And Mr. Chairman, you will note that the first opinion dated 1st April 2019 was actually...
Chairman, for the record, opinion by who?
By the Attorney General.
Name for our
Attorney
record.
General, my boss, Madam Gloria Kufo.
Proceed, sir. Chairman.
And indeed, that opinion constituted an examination of a draft agreement. And in the regular course of a lawyer's work, whether in private practice or public service, if your client has a draft agreement, and the draft agreement is presented to you for review, the lawyer will conduct a preliminary assessment of the agreement and deliver an initial opinion. After, the lawyer may recommend to the client to undertake certain changes or amendments in relation to certain draft provisions of the agreement. And that's exactly what the Attorney General did in this case. The Attorney General delivered her first opinion on 1st April 2019, and as I indicated, it constituted preliminary observations and recommendations. And the first one contains certain general comments. Part of it will indicate that she recommended that there be insertion of this provision or that provision, and that even certain provisions would infringe on the exchange laws of the country and have to be taken out.
Chairman, may I request of you that if the nominee wants to quote verbatim from it, we would appreciate it. Or we have an assurance that he will tender this in evidence to our committee for our purposes. But if he can emphasize the areas to which, when you say general and specific, we are not holding it to follow you. Right. So for our purposes, we need to be guided. And then, if you just give the date of 1st April 2019, if you have the date of the second and third opinion, just give it to us. And then I take chairman's lead that you would make those documents available to us. And then mine is, you share the view that Gloria Akufu, respected Attorney General as she then was, did this within her mandate under Article 88 of the Constitution. Do you share the view?
Fully. I fully share the view, and I also will add further that the 1st April 2019 letter by the learned Attorney General did not constitute a final opinion on the matter. And Mr. Chairman, if I may quote from the first paragraph of the letter, it says, we have reviewed, the first letter is referred to a letter dated so and so. In the second paragraph, we have reviewed the draft agreement as well as the relevant law and make the following observations and recommendations. So whatever followed constituted recommendations based upon her initial review. Mr. Chairman, I'm prepared to tender that document if I'm requested to do so. Then there was a reply from the Minister of Finance. The Attorney General looked at the Minister of Finance's reply and wrote another letter dated 28 May 2020. Mr. Chairman, the first paragraph indicates.
And just clarify, letter or opinion? The first you said opinion, 1st April 2019. Yes. This one, is it a letter or opinion? What is your description?
Gentleman, it was further observations contained in a letter.
Okay, thank you.
So the Attorney General wrote another letter, further bringing to that Minister for Finance's attention more observations that she had made upon the perusal.
I'm sorry, the date, the further observations.
And it was dated 28 May
28th
May 28 May 2020. 2020. Because the reply from Minister of Finance came on 18th March 2020. The first letter by the Attorney General compelled the Minister of Finance to undertake a review of the transaction, and I believe that it took quite some time. So they delivered their reply about 6 or 7 months later, and that was dated 18th March 2020, which the Attorney General by this letter, 28th May 2020, replied. And it's also available. And Mr. Chairman would note from the comment that it again did not constitute a definitive opinion on the matter at all, because it contained only further observations and requests for the alteration of certain provisions of the transaction. And the Attorney General indicated a satisfaction of certain things that had been explained to her, pursuant to the letter that she had earlier on written. So, the Chairman, that is also there. The Minister of Finance, a month later on, replied through another letter dated 22nd June 2020 and brought to the Attorney General's attention further amendments to the transaction documents. The Chairman, that can also be tendered. And the Attorney General conducted further review of the draft agreements that had been made again, and by another letter dated 22nd July 2020, also furnished further comments which will aid a revision of the transaction. So it's also signed by my boss, Madame Gloria Kufu, dated, so that can all be tendered. The Chairman, there was another letter written by the Attorney General dated 5th August 2020. And that, as far as I know, was the last correspondence from the Attorney General to the Minister of Finance before the President's directive that the transaction be looked at again. So, Mr. Chairman, in terms of the observation by a person that the Attorney General was opposed to the transaction, I believe that that is egregiously wrong. It's very wrong and must be corrected. Indeed, all I have before me are a series of letters containing observations written by the Attorney General, most of which were incorporated into the revised drafts that were undertaken by the Minister of Finance.
Just a little clarity. So by your submission so far that I have followed religiously, are you seeking to disagree with Attorney General Gloria Akufo, or you are leaving a thesis that she was not opposed to the transaction? What are you seeking, just for purpose of clarity?
Gentlemen, indeed, I stand with all respect by everything Madame Gloria Akufo did in respect of this transaction, and I'm not opposed at all to anything she did. Secondly, I'm only indicating, for the record, that the Attorney General, Madame Gloria Akufo, at that time was never opposed to the transaction, and that is clearly discernible from a perusal of all the documents before me. And her final letter, actually, was an indication. I think it's very important to note that the final letter written by the Attorney General, which I indicated, 5th August 2020, comments as follows. The opening paragraph was refer to your various advice dated. So she indicated various advice dated 1st April 2019, 28th May 2020, 22nd July 2020, and the transaction advices comments dated 12 June 2020 and 22nd July 2020, respectively, on the Kingdom investment arrangement for proposed monetization of Ghana's mineral royalties. And the second paragraph says, we note that the TA, that's the transaction advisor, has incorporated some of our previous comments into the agreement, whereas he has raised issues with others for our reaction. We have studied TA's responses and comments as follows. And then she made further observations and comments. And those observations, as far as I'm concerned, usually were cast, conditionally, that if this can be done, then this will follow. I believe that when the committee looks at it, the committee will be better appreciative of the position I've taken.
Yes. Are you done? Your mic, please. Nominee, your mic.
Thank you very much, Mr. Chairman. Beyond the furor and then indignation that greeted the Ejapa deal, and all that you know and all that you have told the committee, do you see any vitiating factor, anything that will vitiate this contract, or you think it's perfectly impeccable, in the language of Right Honorable Peter Aladede? Perfectly impeccable.
Mr. Chairman, the Right Honorable Aladede described it as perfectly impeccable. I'm not sure.
He's saying the language of means he's referring to something else he had said earlier.
Okay, so where is that he used to? He very much laughed. Mr. Chairman, I, with all respect, cannot see any vitiating factor with regards to the transaction. I think I may place on record that the special prosecutor...
Chairman, just for the record, the Honorable Tampule used the word vitiating to a contract. In your answer, you are saying vitiating to a transaction. Words matter for our purposes. What word do you want to use for purpose of vitiation?
Right. Gentlemen, let me ask you clarity with regards to which of the contracts, because there are a number of transaction documents. Is it the mandate agreement? Is it the mineral royalty agreement?
For the records, I'm referring to the mandate agreement. I'm referring to the mandate agreement, just for the records.
I'm very grateful. Gentlemen, in terms of the mandate agreement, there are three major factors that were cited by the former special prosecutor, as if one may describe it, as constituting vitiating factors. Now, the first one is the lack of capacity of the Deputy Minister for Finance to execute the transaction. That I have addressed, and I would not bore the committee with further comments on. The second observation was with regards to the alleged unconstitutionality of the mandate agreement. And Mr. Matiamidu contended that to the extent that the mandate agreement was not presented to this Honorable House for agreement, it was null and void. Because his understanding was that the mandate agreement constituted a business or economic transaction because it was with a foreign entity. And therefore, by operation of Article 181, Clause 5, it should have received parliamentary approval. Gentlemen, I disagree because Article 181, Clause 5 has been interpreted by the Supreme Court on numerous occasions. Apart from the initial one, Ferro-Atlantic, Attorney General versus Ferro-Atlantic matter, there has also been Attorney General versus Bakan Energy, reported in, I think, 2012, I'm very sorry, 2012, volume 2, Supreme Court of Ghana report, at page 998. And I think that it's very important to also place on record that Mr. Martin Amidu was the Attorney General then, and he prosecuted the case on behalf of the government of Ghana. And in that matter, with all respect, what constitutes an international business transaction was examined by the Supreme Court. And the Supreme Court came to the conclusion, the holding, that it is definitely impracticable to have every international business or economic transaction come before this honorable house.
Chairman, I'm enjoying the submission of the nominee. You referred to the Ferro-Atlantic case, you referred to the Balkan case.
Yes.
I'm also aware of Martin Amidu versus Attorney General.
Yes.
Can you quote exact which one you are relying on for our record, since it's a Supreme Court ruling? Thank you.
Very well. So the one that I was just referring to is Attorney General versus Bakan Energy Ghana Limited and another, reported in 2012, volume 2, Supreme Court of Ghana report, at page 998. And indeed, if I may quote for the committee, just briefly what the Supreme Court stated. At page 1032, the court indicated that for clearly, it would be impractical for Parliament to scrutinize and approve every single business transaction with international ramifications entered into by the executive. In our view, to give effect to the famous purpose, there is need to imply into Article 181, Clause 5, an understanding that only major international business or economic transactions are to be subject to its provisions. Then the court also continued at page 1033.
Chairman, so I'm following through. Only major.
Only major. That's the first one.
So, by your assumption, was Japan major or minor? Relating it to what you just quoted, was the Japan transaction, mandate agreement, major?
The mineral royalties agreement itself was a major transaction. And I'm saying so because the Supreme Court in this same case construed a major agreement to be the substantive or primary agreement.
Chairman, my follow-up is specific. Was the Japan royalties transaction a major transaction in your view or not?
There's nothing like a transaction that has been signed by the government of Ghana. There were agreements signed by the government of Ghana. So there is one.
So if a transaction is not signed, Chairman, how can it be vitiated?
Your words. That is why your earlier question was very important. You sought clarity of the honorable member, which of the agreements he was referring to. The honorable member alluded specifically to the mandate agreement. And I'm saying with all respect that the mandate agreement in the circumstances was not a major agreement. It was not a major agreement because it was not the primary or substantive agreement itself. And the Supreme Court...
So the mandate agreement on EJPA,
yes,
in your view, was not a major international economic transaction?
Yes.
Thank you. That's all I wanted to say.
But I must explain why it was not a major agreement. And I'm saying that in Bakan Energy, the Supreme Court construed a major agreement to be the primary agreement itself. So all other transactions or agreements that flowed from the primary agreement or could be construed as subsidiary need not be submitted to this honorable house for approval. Indeed, Bakan Energy, the reason why the court declared the transaction as unlawful or unconstitutional was that the agreement in question was a major one. It was an emergency power purchase agreement. So the power purchase agreement itself was a major agreement. But then other agreements like, say, an agreement for the furnishing of a letter of credit and such do not have to come before this honorable court. Indeed, the mandate agreement was an agreement for the appointment of a transaction advisor. And all the records of, with all respect, this country, even before 2012, has pointed to the fact that whenever the Minister of Finance is entering into a transaction agreement, it does not, for the appointment of a transaction advisor, it does not submit it to this honorable house for approval, because it is not a major agreement. And I may, if the committee will permit me, quote from page 1033. It said that, on the other hand, the framers could not have intended the obvious and foreseeable paralysis from overloading Parliament that would ensue from interpreting a provision as covering every single business or economic transaction with an international dimension. The implication into Article 181 Clause 5 of the attributes of being major before a transaction enters into its ambit would thus seem to be necessary and reasonable and within the spirit of the Constitution. Then it says, the defendant's hypotheticals are only a sample of many other transactions which could literally be brought under the umbrella of an international business or economic transaction, but which would not be so construed. So it goes ahead. Indeed, the example that was quoted by the defendants in the matter was, what if the government of Ghana, for instance, is buying air tickets for the travel of,
Chairman, just one more.
Of people? Yes, of course.
You want to refer to which ratio, whose ratio decidendi are you referring to for the purpose?
Right. The judgment of Dr. Justice.
Justice, the full title.
His Lordship Justice Dr. Dateba, JS.
Dateba?
Yes, please.
JSC.
Yes, please.
Okay, thank you. Just for the record, we needed to know who you were quoting as your authority. Thank you.
So, if one were to apply the holding in this case to the transaction in question, I will submit finally that to the extent that Parliament had considered and approved the substantive agreement itself, the primary agreement being the mineral royalties agreement, other subsidiary agreements, like an agreement for the appointment of a transaction advisor, ought not to have come before the Honorable House for approval.
Very well.
Mr. Chair.
Yes.
Honorable nominee, is it your case that...
Are you doing a follow-up on any
yes,
matter?
please.
Otherwise, I should go to...
Just a follow-up on the
Yeah.
point you made. Is it your case that the transaction itself did not have government as a party, and that it is by entities that are independently registered to operate with that capacity? Is that your case by way of your response to the question?
Gentleman, that is not my point at all. The point I made was just simple. The transaction was between the government of Ghana and certain entities. Indeed, the transaction that is being impugned here is a mandate agreement executed between the Ministry of Finance on behalf of the government of Ghana, necessarily, and Imara Company, South Africa, as well as Data Bank of South Africa. And the question here was whether the presence of the Imara Limited, which is a South African company, made it an international business economic transaction for the purpose of Article 181 Clause 5. And my contention is that, as the Supreme Court has held in the Balkan case, it's only major agreements that ought to come before this Honorable House. A major agreement necessarily should be in reference to the primary agreement itself. The primary agreement had come before this Honorable House, and therefore such minor agreements which would facilitate the execution of the primary agreement ought not to have come before this Honorable House.
Yeah. Honorable Agaga.
Now, Mr. Dami, you have sought to distinguish between the Attorney General versus Faro Atlantic Company Limited and the Balkan case. And it is your view that the mandate agreement did not constitute a major agreement to have warranted parliamentary approval. Now, let me ask you this question. What was the fee that Imara, under the agreement, was supposed to be entitled to?
Mr. Chairman, I think it was $15,000 per annum. I stand for correction, but I think it was $15,000 per month. $15,000 per month.
Now, beyond that, what was supposed to be the success fee, that is, following the consummation of the deal in terms of the services Imara was supposed to render?
Mr. Chairman, this percentage was also indicated in the agreement. I think it was, Mr. Chairman, if I may respectfully be specific by referring to the agreement itself. Chairman, but per my crude reckoning, I think an amount between about 3 and 4 million, if the transaction eventually became successful, would have been paid. But that's just my crude analysis.
We want what is in the agreement. Your reckoning may not be correct, and our record must reflect.
So we can make progress. Yes, Mr. Nominee, the figure in question is actually $4 million.
4 million.
Yes.
So, Mr. Chairman, my crude mathematics,
Yes,
my crude mathematics was quite right. I was looking for the agreement itself, but if the honorable member has it before you and us.
Now, Mr. Dami, would you still insist that a transaction which involves the payment of 4 million United States dollars to a foreign entity would not qualify for a major business transaction?
Mr. Chairman, with all respect, in terms of the character of the agreement and in terms of the quantum of the sum, they do not qualify as international major agreement, major business or economic transaction. I will explain so because fundamentally, to the extent that it was not the main agreement regarding the transaction, it did not even qualify at all. Secondly, even if it did, on account of it being $4 million, I'm not trying to be, in fact, I do not have $1 million, but I'm just saying that in the scheme of things, it does not qualify for a major business agreement. Because, as was alluded to in the matter, the situation where the government of Ghana buys air tickets for its public officers will be material. It never comes before its honorable house. Indeed, the government of Ghana buys air tickets all the time, I'm sure definitely every year to about $4 million or more. It never comes before its honorable house. So I think that we ought not to look at the quantum as constituting a basis for subjectivity. Because the first fundamental requisite, that's not even coming. It's not a major agreement in the sense that it's not the main agreement. It's only a subsidiary agreement or an agreement which facilitates the execution of the main agreement.
But, Mr. Dami, you would agree with me that the agreements in question, all 5 of them, the gold royalties monetization transaction agreements, were intertwined. In other words, they were interwoven in such a manner that to take out one in isolation and place meaning onto it without reference to the others would lead you to error?
No, Mr. Chairman, I respectfully disagree. That is why I did not refer just to the Faro Atlantic case. When the Faro Atlantic case, the question as to whether each international agreement ought to come before the Honorable House was also considered, was just the broad question of whether Article 1815 should be construed to mean international agreements should come before this Honorable Court and this Honorable House. And the court answered in the affirmative. The only time the Supreme Court had opportunity of considering the elements of international business or foreign transactions was in the Balkan energy case. And indeed, with all respect, I'm not the Supreme Court judge. The Supreme Court itself, which is the highest court of the land, held that it would be impractical and it would be one which sounds in absurdity for every economic or business transaction, international business or foreign transaction, to come before this Honorable House. It should be only major agreements. And the major agreement is the agreement itself, from which such small issues as appointment of a financial advisor will flow from.
Mr. Dami, before the appointment of the transaction advisors, you know, under the Public Procurement Authority Act, the bidding process had to be complied with. Nevertheless, now is it your case that that particular procedure captured under the Public Procurement Authority law could also have been glossed over because this transaction was minor in nature and character?
Well, Mr. Chairman, I'm very happy the honorable member, my very good friend, you have a nickname that I will later on tell Mr. Chairman that you were called by when we were linking up about 20 years ago. Now, Mr. Chairman, the Solar prosecutor indicated also in his report that the mandate agreement was vitiated by the lack of procurement approval. And the reason for so holding was that Data Bank, which was also a signatory to the agreement, was not one of the companies mentioned in the PPA approval to engage with the tendering. And again, with all respect, I will disagree with that finding. I disagree with the finding because the documents I have seen will show that by a letter dated a letter dated 6th October 2017, the Minister of Finance requested from the Public Procurement Authority approval for direct invitation of certain companies to be appointed as a transaction advisor in this matter. By
Chairman, just letter dated 6th October
2017.
2017.
Yes, please.
And the letter is from
Minister of Finance to the Public Procurement Authority.
Addressed to
the Mr. ABJ, Chief Executive Officer, Public Procurement Authority.
All right, thank you. Chairman will request that he also submits that in evidence for our purposes. Thank you.
Mr. Chairman, it is headed Request for Approval for Direct Invitation. And it goes, just a very short letter, and talks about the need to appoint a transaction advisor, and therefore they are applying to PPA for approval in that regard. The PPA, by a letter dated 6th November 2017, referred to that letter and requested the Minister of Finance to do two things. It says, one, a list of the shortlisted firms to include their SNATE tax and VAT certificate. And then two, the estimated cost breakdown of the assignments we are undertaking. Chairman, the Minister of Finance complied, and by...
Chairman, again, you said three things. You've mentioned two. List of shortlisted firms, cost breakdown. The third, you started with three.
That's
if it is two, I'm fine.
Two things. I said two things.
Two things, okay.
Yes.
List of shareholders.
List of shortlisted
firms for
the transaction.
Which transaction?
Technical advisor or transaction advisor? The transaction advisor. Transaction advisor.
For the activity.
Chairman, in the Minister of Finance's letter, it said they were implementing the Minister of Finance.
You want to read the heading in full? The 16th November 2017 letter from the PPA to the Minister of Finance.
Chairman, the PPA was replying to the earlier letter from Minister of Finance.
Yeah, I just want the heading.
Okay, so the heading was by the PPA, the PPA letter?
Yes.
Oh, it said request for approval for direct invitation.
Thank you.
/ technical advisor. And it goes ahead. And, Mr. Chairman, there was a reply to that letter by the Minister of Finance, and it was dated 14th November 2017. In that letter, the Minister of Finance indicated a short list of 8 firms, international firms: JP Morgan, Goldman Sachs, Imara Corporate Finance, Citibank, Morgan Stanley, Barclays Bank, Standard Chartered Bank, and Rothschild and Co. And then indicated at paragraph 3 of the letter that the above listed firms are international firms and are unable to provide the PPA with valid VAT, SNATE, and tax clearance certificates. Because of course, I'm sorry, I said the court. The committee will understand that indeed, because they are foreign firms, they cannot have VAT or SNET forms. The Chairman, by a letter dated 16 November 2017, the Public Procurement Authority granted approval, and this is very important, granted approval under Section 38A of Act 663 to use the restricted tendering method to engage a transaction advisor among the list of selected firms.
Chairman, just the date again, the approval letters date.
16 November 2017, 16th November.
16.
16.
Thank you.
November. And the approval was under Section 38A.
Of Act 663.
Yes, please.
Thank you.
And Mr. Chairman, I consider the Section 38 very material because Section 38A of the Procurement Act regulates restricted tendering. And if the committee looks further beyond Section 38A and looks at Section 39, subsection 3, it stipulates that the provisions of Part 5, but not Section 47.
Chairman, just clarity. In the approval letter, reference was made to Section 38A of Act 663.
Yes. And
what you are referring to, was it referred to or you are referring to it?
Chairman, they go together. They go together.
No, and I'm saying, was it referred to by the PPA in their letter or you are making reference to it?
Chairman, it was not referred to the PPA letter.
Thank you, that's fine.
But it constitutes procedure for restricted tendering.
Thank you.
Want to differentiate between what is in the letter and what is your addition?
Very well. Chairman, what is in the letter, Section 38A? Indeed, the provision itself should have been Section 38(1)A. There's nothing like Section 38A, so it should have been Section 38(1)A, as Section 38, subsection 1, paragraph A. It's a general direction for restricted tendering to be engaged in by an entity, a general permission in that regard. Section 39(1) is what sets out the procedure for restricted tendering. So, Chairman, definitely it cannot be right or justice will not be served by taking account of only Section 38(1)A. Because indeed, when an entity is giving approval under Section 38(1)A, that entity will have to comply with Section 39. And Section 39 is what sets out the procedure.
It's appreciated, but just to elucidate further information, do you serve on the PPA?
Yes, Chairman, I do.
And at that material time, you were a member of the PPA?
Yes, Chairman, yes, please.
Thank you. Thank you. That's fine. Thank you.
Mr. Chairman, the point that is made by reference to Section 39 is that when approval is given by an entity to conduct restricted tendering, that approval enjoins the entity in question to adopt all the procedures for a tender. And first, the entity will have to launch its own rules for the tender. So the rules for the tender will then have to be regulated by Section 39, and as I indicated, Section 39, subsection 3 will say that the provisions of Part 5 of the PPA Act will then apply to the tender. So the Ministry of Finance, upon a study of the documents that I have, then set out to launch its tender. And the tender is governed by rules determined by the entity. The Chairman, the PPA, Public Procurement Authority, does not launch a tender. It doesn't open a tender at all. And it doesn't set rules for a tender. The rules for a tender are usually set by an entity. Mr. Chairman, I have seen a document titled Confidential Report. That Chairman, even though it's confidential, it was from the Ministry of Finance, and I'm a public officer. I'm appearing before another public institution Parliament of Ghana. And therefore, I take the view.
Honorable member, this is a public hearing.
Yes, the public
If
hearing.
you consider it confidential, please table it. We'll look at it.
Very well. That's why I'll table it, but it's the report of the evaluation. And the report of the evaluation of the tender will show that the Ministry of Finance set out rules for the tender. And the tender rules required that any of the firms which have been approved by Ministry of the Public Procurement Authority was required to engage in a tender pursuant to collaboration with a local entity. So indeed, a foreign firm which had been listed could only bid or was encouraged to bid after forming a consortium with a local firm. And Mr. Chairman, that requirement or permission to form a consortium with a local firm to bid for a procurement or to participate in a procurement activity is not offensive or alien to the PPA at 663. Mr. Chairman, that is why I take the view that indeed the mere participation of a local firm in the bidding process did not violate at 663. And I would also add that the rule or the requirement for a foreign firm listed among the firms that have been approved by PPA to enter into a collaboration with a local entity was not discriminatory at all. It was not discriminatory because that rule was open to all the firms that engaged in the transaction. So the report that I have before me, which pursuant to the advice of the minority that I will table, will show that in spite of the 8 firms having been invited, only 2 eventually submitted the application. And the 2 firms which submitted the applications both had local firms. So that supports the contention that the requirement for the firm to have a local collaborator, if I may say so, was not discriminatory. And Mr. Chairman, I have not seen any provision of accessory that is violated.
The question you were asked, I thought you have answered it. So leave it. If you want another question, they will answer it. Otherwise, we will spend the whole day here today. Yes,
I'm very grateful.
Yeah. Now, Mr. Dami, you sought to suggest that the submission of a report by the special prosecutor to the president was not warranted by any law. But you would agree with me that the mandate of the special prosecutor included implementing strategies to prevent. So the preventive mandate of the special prosecutor to corruption also made it possible for him to conduct the risk assessment of corruption that he did in respect of the gold royalties transaction agreements.
I think 2 points are embedded in the question. The honorable member, if I got him correctly, is indicating that I suggested that the referral of the special prosecutor, referral by the special prosecutor of his report to the president was not warranted. Was that part of it? Yes, that one, without any reservation, I'll contend so, because there's no provision which requires an investigator to submit his report to the president. The CID conducts investigations all the time. The IOCO conducts investigations all the time. And whenever they do, they present their report, if any at all, to the Attorney General for the Attorney General to prosecute. And in this case, a special prosecutor had prosecutorial powers. And if he has prosecutorial powers, he just proceeds to prosecute. That is one. The second point too is whether the corruption risk assessment did not violate Section 2. Is that your question? Okay.
From your answer, what I could deduce is that you were suggesting that the procedure of submitting a report to the president in itself was wrong in law. Now, but do you know that corruption in itself has so many implications, including security implications for the country, and that the president, as chairman of National Security Council, is entitled to receive such reports from an investigator, such as a special prosecutor? There's nothing wrong with that.
Gentlemen, there's nothing wrong with that. Indeed, he can do as he desires with his report. The point I'm making is that in terms of the law, he is not mandated to present his report to the president. He could have acted on it. He chose to have regard to certain considerations and present it. And I think it is very fair to him to also indicate that he stated the reason for so doing. He stated that the report was supposed to guide future executive actions of government. And that is why I also added that if the report was intended to guide future executive actions of government, and the president acting on this statement requires the public officer affected to present his version of facts on the report, then it cannot be wrong.
No, let me move away from Ejapa and follow-up questions. Yes.
No, remember, even with follow-up, you have more than, I'll give you one more.
Very well, yes. Now, Mr. Dami, I want us to talk about public order here. Public order, yes. You are the Attorney General designate. And so definitely issues bordering on public order would fall within your province if you're given the nod. Not too long ago, the Greater Accra Regional Police Command went to court and obtained some injunction order. The injunction order was obtained without recourse to service of whatever process they may have filed before the court on the NDC as a political party, even in the face of some decisions of our courts, which clearly states that in matters of the enforcement of public order in respect of the right to demonstrate, ex-party injunction applications are completely prohibited. I'm referring to the Occupy Ghana, famous Occupy Ghana case, in which Denis Ajay, a Court of Appeal judge, sat as an additional High Court judge and made that famous pronouncement. Now, should you become Attorney General, what would be your attitude towards the enforcement of the right to demonstrate, which is fundamental under our Constitution?
Chairman, I think that Justice Denis Ajay, even though a Court of Appeal judge, gave that judgment as a High Court judge. So the decision in the Occupy Ghana case was actually a High Court judgment. And it did not matter that the judge who constituted what the lawyers call the quorum, was a Court of Appeal judge. It still was a High Court decision. Now, it's very relevant because the case you refer to, which is the application for an ex-party order by the police service earlier this year, around 5th January or so, I think, it was or just before the Christmas, was also a matter before the High Court. And stare decisis, the principle of stare decisis, that is the principle which requires judicial precedent to be observed, is very fundamental to our jurisprudence. And a High Court decision is not binding on another High Court. We all know that. It's actually decisions of other superior courts, Supreme Court and Court of Appeal, which are binding on the High Court. So I would say that fundamentally, one cannot say that merely because the High Court differently constituted in the matter that we refer to, came to a conclusion or granted an application in a manner different from the judgment or the terms of judgment given by Justice Denis Ajay. The High Court was in violation, or the High Court disobeyed the principle of judicial precedent in that case. I think that must be made correct. Because indeed, both courts were courts of coordinate situation. If the High Court gives a decision, another High Court takes a course different from the course that had earlier on been taken by another High Court. There's nothing wrong with that at all. So for me, there has not been a categorical pronouncement on the issue raised by Justice Dennis J, whether an ex parte application can be applied for under the Public Order Act. And I think that sometimes the circumstances of the occasion may warrant. In fact, what the provision says is that the police, when it has indication that a prospective demonstrator seeks to proceed with the demonstration, may apply to the High Court for an order. Now, when it applies to the court, the manner in which it applies, whether it's by ex parte application or notice, is not indicated in it. That is what warranted the early application in the Justice Dennis, the matter not authenticated upon by Justice Dennis J. So I think that there ought to be a categorical pronouncement on the issue. But of course, the relevant circumstance the court found itself in the matter in question was very material.
Nominee.
Was very close
You
to
have
Christmas.
two judgments from Court of Coordinate Jurisdiction saying two different things. The question is, what is your own? You want your own attitude towards that?
Gentlemen, I am inclined to go on notice in such circumstances in accordance with the principle of fairness. I'm a fair-minded practitioner. I like to do that. But I think that sometimes, if the police finds itself with a possibility of a demonstration in the course of the Christmas holidays, say 29th December or 3rd January, and the courts are going on a break in accordance with CI 47 from 23rd December, I think the police may be compelled to go ex parte. But that ex parte application ought to be made rarely, very sparingly.
Yes, Honorable Biamo.
Thank you, Mr. Chairman. Congrats, Godfred, for the nomination and the elevation to the big position of Attorney General. Now, I'll start with some of the cases that you've listed regarding your CV. I see that many of the cases listed are related to social legislation cases. And I will ask these three in one question. What are the challenges associated with the regime of subsidiary legislation in Ghana? What reforms would you undertake regarding subsidiary legislation? And do you agree that we should have an act on subsidiary legislation? And how soon will a bill be brought to Parliament? You have the questions. 3 in 1. Yes.
So we have challenges with subsidiary legislation.
Challenges associated with it.
Whether
Yes.
I think there ought to be legislation and how soon.
Yes. Reforms and how soon you think that we should have an act.
Right. Sure.
Yes.
Everyone, the challenges with subsidiary legislation are contained in the formulation of Article 11, Clause 7 itself. It says any other rule or regulation made by a person or authority under a power conferred by this Constitution or any other law shall A, be laid before Parliament, B, published in the Gazette on the date laid before Parliament, and C, shall come into force at the expiration of 21 sitting days after being so laid, unless Parliament before the expiration of 21 days announce the order, rule, or regulation by the vote of not less than 2/3 of all members of Parliament. Mr. Chairman, the first problem is with Article 11, Clause 7, Paragraph C, that Parliament is divested of any power or authority to amend a subsidiary legislation once it is laid before the House. So, Parliament, in accordance with the ratio of the Supreme Court in some of the cases that I conducted, which my very good friend, the honorable member, has alluded to, the Charles Matikole and attain your
Honorable nominee.
country will be properly protected and nothing else. In the course of time, the Millennium Challenge Corporation itself had also conducted their own investigations. Mr. Chairman, and the report was by an entity called FTI Consulting, dated 30th August 2019. And their report, with all respect, made for very interesting reading. And they indicated at page 19, so when the font size is very small, that's why sometimes I struggle, I'm sorry, that real authority, that based on our review of the document, output does not seem, that Mr. Nuri is the gentleman, the rogue gentleman who had executed all those documents on behalf of output. It does not seem that Mr. Nuri was authorized to execute the guarantees, although the technical document authority list includes Mr. Nuri as an authorized signatory to technical document. It fails to define or detail what is meant by a technical document. Then it further went on to say that while there was no provisions in local law that set out the concept and doctrine of apparent authority. So the FTI company went ahead to make the finding that even though the gentleman who had signed the letters on the basis of which the demand guarantees had been allegedly issued by output did not have real authority, under the laws of Qatar, the government of Ghana could proceed against the insurance company in Qatar on the doctrine of what it called apparent authority. And that apparent authority was per a decision of the court of Qatar. Mr. Chairman, the absurdity to all of this was that the court of Qatar did not apply the doctrine of stare decisis. They did not. Secondly, it would also have been, with all respect, a little bit incongruous and irresponsible for the government of Ghana to proceed all the way to Qatar to engage in litigation to confirm the validity of a demand guarantee based on a decision of a court of Qatar which was not binding on the court of Qatar. In the face of all of this, after about 3 or 4 months of an opportunity given to PDS to produce another valid demand guarantee, and same had not been duly taken, the government of Ghana, or ECJ, I'm sorry, decided to terminate the agreement. So this, with all respect, constitutes the material fact resulting in a termination of the demand guarantee. And I think that it was very proper and right in the circumstances.
Very well.
Chairman, just, you have a date of termination?
Yes, Mr. Chairman.
For the PDS agreement. Just quote it for our purposes. Thank you.
Yes, Mr. Chairman, dated 23rd October 2019. 23rd October 2019.
Honorable Samsai.
Right.
Thank you very much, Mr. Chairman. Mr. Chairman, the honorable nominee is accused of leading the effort to disenfranchise voters in the Central Kofi, Kafo, Lolobi areas in the Volta region. What do you say to this?
Mr. Chairman, I think it will be very unfortunate for anybody at all, with all respect, to characterize the role I played in ensuring a preservation of the right to vote of the
Honorable
whole
member,
people.
let me remind you of Order 93.1 so that you'll be guided in your comments. Reference shall not be made to any matter on which judicial decision is pending in such a way as may, in the opinion of the Speaker, prejudice the interests of parties to the action. So, whilst I'm listening keenly, if I have to stop you, I will.
Yes, if Mr. Chairman, I am very mindful of that, and I think that I must place on record that the decision in the Hohoi matter, what we call the SAL matter. It is ex parte Attorney General. Was an application filed by the Attorney General to quash a decision of the High Court in a matter that has been filed by 5 residents of Hohoi, led by Professor Margaret Kweku. That decision has been a side part of a review application by the respondent, Mr. Professor Margaret Kweku, led by Mr. Chatuchikata in the Supreme Court. Gentlemen, just by way of interest, I would say that indeed it will be unfair for any person to say that I led the effort of the people of Hohoi to disenfranchise. If anything at all, it's the opposite, which is the case. I ensured the preservation of the right to vote of the people of Hohoi, because the SAL area, as far as I'm concerned, clearly has, by dint of CI 128, Representation of People's Parliamentary Constituencies, been placed in the Buem constituency, not Hohoi constituency. So, if the committee looks at page 71 of CI 128, it shows that the SAL areas had been clearly placed under Buem in Oti region and not Hohoi in the Volta region. So when indeed an application was filed by them and others made to restrain the Member of Parliament elect for Hohoi at that time from being sworn in, of course, the Attorney General was also a party to the application. The Attorney General was compelled to file an application in the Supreme Court, because to start with, the matter that went to the High Court, who, insofar as it affected the right to be sworn in by the Member of Parliament of Hohoi, should not have been filed in the Human Rights Court, because it was a election petition. The Attorney General felt concerned, and acting in accordance with my understanding and conviction, I filed this application in the Supreme Court, and the Supreme Court unanimously upheld my submissions and quashed the orders of the High Court rule. But the main point of concern is that the people of SAR are not by law required to vote in Hohoi. They have been placed in Buem in the Oti region. And I remember making a submission in the Supreme Court that if there were any group of people affected, it should be the people of Buem. And therefore, I will lead efforts to ensure that the SAR people vote in Buem constituency. And if by the grace of God, this honorable court, this honorable house approves of my nomination, I will, in accordance with that submission, ensure that the people of SAR vote where they are supposed to vote, that is in Buem, and not Hohoi.
Thank you, Mr. Chairman. Mr. Chairman, after the Ayawaso West Wagon by-elections, the government constituted inquiry into what happened after the by-elections. Now, in a short committee issued their report, and the government issued a white paper which rejected most of the recommendations made by the short committee. That white paper was signed by the Attorney General. Do you think that rejection by the government, that decision by government, is in the interest of good governance?
Okay, Mr. Chairman, I would say with all respect that to start with, the prerogative of the president to issue a white paper stating a position on the findings of a commission of inquiry is in the best interest of good governance, because that is actually the purport and effect of Article 280 of the Constitution. And Article 280 Article 280, Clause 3, stipulates as follows: the President shall, subject to Clause 4 of this article, cause to be published the report of a commission of inquiry together with the white paper on it within 6 months after the date of the submission of the report by the commission. Then Clause 5, also Clause 4 first, says where the report of a commission of inquiry is not to be published, the President shall issue a statement to that effect, giving reasons why the report is not to be published. Clause 5 says, a finding of a commission of inquiry shall not have the effect of a judgment to the High Court, as provided under Clause 2 of this article, unless, and B for me is most relevant, the government issues a statement in the Gazette, in the national media, that it does not intend to issue a finding upon the report of the Commission, whichever is the earlier. So, with the greatest respect, it shows clearly that the President has been mandated by the Constitution to issue a white paper stating a position on the report of a commission of inquiry. And the precondition to the findings of a commission of inquiry to being construed as a judgment to the High Court is actually predicated on the issuance of a white paper. And for that matter, if the President does not intend to do so, he ought to state it. And if he does not do so, the report does not become judgment to the High Court. Now, I say that the Constitution has cast provisions in this way to show that the work of a commission of inquiry itself is part of the executive functions of government. So a commission of inquiry, or a commission of inquiry's work is part of the manner in which the executive powers of government are exercised. That must be construed. The fact that the report of a commission of inquiry can, subject to certain conditions, become a judgment to the High Court does not derogate from the basic fact that the work of a commission of inquiry is part of the exercise of the executive powers of government. It's actually government, it's part of the government work. Now, the government was compelled to issue a white paper assigned by my former boss, Madame Goekufu, and the reasons have been stated there. And the committee will see that the reason why the government was compelled to indicate in a stencil its acceptance or rejection, or partial rejection and partial acceptance of the report is on account of the manner in which the work of the Commission of Inquiry itself was done. So, in the greatest respect to the membership of the committee, one of them, my former lecturer, Professor Rita Mesa-Bosu, and the other, a very eminent jurist, Mr. Emi Short, and the other two, a very important or a police officer who served the nation well, former IGP. Some of the findings were internally inconsistent. So, to start with, the commission represented, as far as I'm concerned, a very bold initiative of a government.
Honorable, I think you're elaborating. Kindly come to a conclusion on this matter.
I think that I might just try to indicate some of the inconsistencies. So for instance, where the
document is available to
it's available, fine. So some of the findings were inconsistent, and that has. And then also, I may also just to indicate the boldness initiative, refer to the Hansard of this Honorable House. There is the record of proceedings of parliamentary debate dated 7 July 2011, whereby after the Atiwa incident, the Attorney General was compelled to appear before this Honorable House and justify why certain actions in the nature of either commission of inquiry or prosecution of the members of persons found to have misconducted themselves in the Tiwa incident were not prosecuted. And indeed, the Attorney General then, Mr. Matiyamidu, clearly refused, with all respect, to either institute an inquiry or to prosecute the persons who had been injured and or were the victims of violence in the Tiwa incident. And stated here at page 2360 of the Hansard of 7th July 2011. The column, this Honorable House, it has oral answers. Well, the page is 2360.
We call it column.
Column 2360. Okay, I stand to correct it. The people of Wenchi will be angry with you if you say that. so page 2360, column 2360. You find that Attorney General justifying why action should not be taken after the Tiwa violence. And for that matter, I think that the president who instituted this commission of inquiry and accepted some of the findings ought to really be commended for the bold initiative. But I've explained why it rejected some of the findings, and it was compelled to do so because of the internal inconsistency and contradictions in some of the findings.
Yes.
My second question. Mr. Chairman.
This is your third question.
Oh, the second one was follow up.
How can Iowa should be a sequel to South?
Mr. Chairman, my next question has to do with legal education in the country. In the past, we only had Legon and Tech to offer LLB degrees. So the existing facility could accommodate them to do the professional law degree. But now we know that JIMPA is offering a LLB degree program. Cape Coast is doing the same, and other universities are offering LLB degrees courses. But we have not done much to expand the facilities at the professional level. Will you consider pushing for those universities to offer the professional courses? Apart from that, what would be your suggestion to reform legal education in Ghana?
I'm very grateful, and I recognize that the honorable member is very passionate about legal education. Indeed, my appearance before the committee in 2017, I think the honorable member asked a question on the same lines, and he's sticking to his passion. I think he wants to be a law student, and I'll be interested in taking one as a pupil at the appropriate time. That's one. I think law education, legal education has come a long way. Prior to 2015, the legal education was just, professional legal education was just run on the lines of it was structured in this way, a 2-year course with 12 courses spread over the 2 years. Then in 2015, there was the introduction of entrance, examination, and interviews. In 2018, pursuant to the professional law course regulations, the interview aspect of it was removed, but of course, the examination was preserved. Then there was an attempted restructuring of the course to be on these lines. 1 year professional law course conducted in the classroom, and another 1 year conducted outside. Conducted outside in the sense that there will be pupillage of 6 months in a legal department, firm, or the judicial service. By 2020, the General Legal Council has scrapped that arrangement too. But, Mr. Chairman, it is important to say that all these measures were taken in the interest of boosting the quality of practitioners or quality of products that come out of the law school. And I'm also happy to say that there has been a dramatic proposed change in the structure of the law program. So there has been enacted, not enacted, I'm sorry, there's been drafted a proposed amendment to the Legal Profession Act, because that the change will require an amendment not just to regulations, but this one to the Act itself, Act 32 of 1960. So as to permit the professional law course from being run by the various faculties which undertake the LLB, that's the Bachelor of Laws program. And I think this represents a very bold initiative and which will go a long way to expanding access to law school. Over the years, I have always held the view that the difficulty in having access to law school was occasioned by the disconnect between the manner of regulation of the LLB program and the manner of regulation of the professional law course. Whereas the LLB program was regulated by the accreditation board, National Accreditation Board, the professional law course was run and regulated by the General Legal Council. So you find a situation where there will be in existence many faculties, Cape Coast, Kumasi, and Accra, many of them, and some even Kumasi having campuses in Mampong, what have you, running LLB programs. And eventually, over 1,000 students will be unleashed onto the scene every year. The General Legal Council will still maintain its grip over the professional law course and have only these three campuses, Legon, the old Mapola campus, as well as Kumasi. Of course, there was a limitation in infrastructure. So part of the means to also boosting the fiscal access is to ensure a completion of this law village project, which has been earmarked and I think it's supposed to be around Legon or Pesek, going for a long time. So, Mr. Chairman, I think that an amendment of the the Law Profession Act, the Legal Profession Act, will actually lead to a resolution of the long-standing problem of access to law school. And I'm happy to say that there's a draft bill. I believe that if this Honorable House, by the grace of God, approves of my nomination, I will help in ensuring a swift passage of the law, and will also, apart from that, ensure a completion of the Law Village project. And that will really resolve all the problems, including your giving vent to your desire to be a lawyer.
Yes, Reverend.
Thank you, Mr. Chair, and congratulations, the learned Attorney General and Minister for Justice designate. What is your legal inclination on the advocacies calling for a capping to be put on the number of judges at the Apex Court?
Grateful for the question. Everyone, I think that the question itself has implications for the independence of the judiciary. Indeed, the considerations of a cap or a limitation on the number of judges that, or justices of the Supreme Court that a president may appoint has every relevance for the independence of the judiciary. Because there's worry about a president seeking to maintain its grip on the judiciary, appointing justice on the Supreme Court of Ghana. Now, this country has had a convention of maintaining, even though there's no limitation, a number of about 15 justices on the Supreme Court at the time. Mr. Chairman, I think that the issue can be addressed first and foremost through the appointment processes of the Supreme Court Justice Supreme Court of Ghana. The appointment processes are set out in the Constitution. And my view is that if indeed all parties relevant to the process were to perform their task seriously and faithfully, I think that inherent in that will be that check on a president from abusing his or her powers. So Article 144 plus 2 stipulates that the other Supreme Court justices shall be appointed by the president, acting on the advice of the Judicial Council, in consultation with the Council of State, and with the approval of Parliament. So, Mr. Chairman, we see four main parties relevant to the appointment process of a justice of the Supreme Court of Ghana. The first is the advice of the Judicial Council. So the Judicial Council itself will have its inbuilt mechanism for ensuring a thorough approval of persons, or a thorough scrutiny of persons who may be advised for appointment. I think that would be the first check. And secondly, there's also required to be consultation with the Council of State. Even if the Council of State is seen to be part of the executive, which some theorists will disagree, and I indeed take the view that yes, they are. I think that they can also be a useful check in terms of constitutional arrangement that we have in the country, even if they default on their duties.
Chairman,
the ultimate duty.
Chairman, if I can indulge you, just honorable nominee, you are relying on Article 144. You are entitled to 8, and in your opinion, you are emphasizing on the appointment
process, yes,
relative to the question that our colleague asked. Just read Article 1281. The Supreme Court shall consist of the Chief Justice and not less than 9 other justices of the Supreme Court. What can the appointing authority do relative to this provision? Right. If you marry it, we can enjoy the intellectual discourse on this matter. Thank you.
So, Chairman, Article 128 does not place a cap or limitation on the number of Supreme Court justices. It only sets a minimum, and that minimum is 9. So the Chief Justice plus not less than 9 justices of the Supreme Court that constitute the Supreme Court. Chairman, there is no upper limit, and the upper limit is determined by the substance of the day. Chairman, that is why I'm saying that I consider the appointment process to be very material. And I'm saying that in order to curb a president who would want to appoint as many justices of the Supreme Court as possible by way of a subtle manipulation of the Supreme Court, the various parties involved in the appointment procedure, as set out in Article 144, Clause 2, will be very material. And I'm saying that the first party is the Judicial Council. So the president does not, with all respect, get up and appoint on his own. The president cannot appoint on his own. The president's appointment process, with all respect, will even be considered to be perfunctory, because it is pursuant to activities engaged in by this important element. And the first institution is the Judicial Council. The Judicial Council does not advise for appointment. The appointment cannot commence at all. So if indeed all these parties relevant here were to take their constitutional duties seriously, with all respect, and ensure that even the case or the situation of a president appointing does not arise, there will be a check, or there will be a cure to the problem envisaged by my very good friend, honorable member. That is the point I'm making. And I'm saying that the ultimate word is with this honorable house, because the appointments, the advice, the consultation, and whatever you cannot come into effect without the prior approval of Parliament. And therefore, I consider this honorable house, house's rule very important. So, even without amending the Constitution to place an upper limit or a cap on the appointment, on the number of Supreme Court justices, there is an internal check set by the Constitution itself. for such a restriction to be achieved. Mr. Chairman, I may also add that the problem or maybe the need to appoint many Supreme Court judges has also been rendered necessary by virtue of the combined jurisdictions of the Supreme Court. The Supreme Court is a constitutional court, is an appellate court, is a review court, is an election petition court, and it's also the court set by Article 135 for giving approval for the release of official documents and what have you. So if indeed there is a right of appeal from every decision of a high court to the Supreme Court, apart from matters which have emanated from the circuit court, clearly the committee will see that there's a need for us to have a lot of Supreme Court judges, because unlike certain countries where the Supreme Court is just a constitutional court, or maybe there's even a constitutional court as distinct from a Supreme Court, in this case, it has combined jurisdictions. So one of the processes that I will also, with all respect, try and seriously pursue by way of law reform is to ensure that the Supreme Court itself exercises its own judicial powers to control the adjudication of the plenty cases that come before it. There's nothing wrong, with all respect.
Chairman, with your indulgence, the longer you engage us, the more the period will spend with you. What we want from you,
Right.
if you want to take a middle ground, as I understand you, you are saying that the appointing authority, including Parliament,
Yes.
can exercise a persuasion to limit the numbers. Now, your second argument is that given the multiplicity of the role of the Supreme Court, you are for open-ended. Where do you stand? Are you for capping or not?
Mr. Chairman, I think the present arrangement to the Constitution is sound, is proper, and I've not faulted in any way. And I think that there ought to be rather a strengthening of the roles played by the various.
Are you for capping, limiting numbers to appointment to the Supreme Court as it pertains in the U.S., or you are for open-ended? Just give us an answer for
Mr. Chairman, having regard to the multiplicity of jurisdiction of the Supreme Court, I am not for capping. I am for a strengthening of the rules of the various institutions.
I am now going to limit you, because if I leave you, we're going to spend the whole of the day here. So, yeah.
Honorable Chair, you may indulge me to situate my last question in context and with particular regard to Article 35, Clause 5, and with your indulgence, I read, under the directive principles of state policy, the state shall actively promote the integration of the peoples of Ghana and prohibit discrimination and prejudice on the grounds of place of origin, circumstances of birth, ethnic origin, gender or religion, creed or other beliefs. And with due regard for this provision, to refer the honorable nominee to Section 104, subsection 1B of the Ghana Criminal Code of 1960, which states that unnatural carnal knowledge with consent is considered a misdemeanor. In respect of this particular provision, Honorable Leonard Attorney General and Minister for Justice designate, some activists have posited that this particular provision I made reference to is anachronistic and therefore not sufficient to fully address the emerging matters of LGBT. And in that position are even advocating for further strengthening of our laws to be able to fully address these matters. What is your view on this matter, and what would be your advocacy for the strengthening of our laws to fully address matters of LGBT?
That's one. I take the view that the provision of the Criminal Offences Act does not offend the Constitution at all. I think that, yes, there are cultural rights recognized by the Constitution. My personal view is that it is only when the laws are applied in a way discriminatory of a particular group of people, that you can allege or assert unconstitutionality. I take the view that the decision of the Supreme Court in the James Kobna Bonfe and the Attorney General matter recently regarding the National Cathedral itself is an affirmation of the fact that even though there are multiplicity of religions in the country, freedom of religion, and what have you, any decision by a president to promote a particular religion is not discriminatory. In the same way, any practice of a people which seeks to protect its customs and values cannot be deemed to be discriminatory. And for that matter, I would agree that the section of the criminal code is not discriminatory at all. I think that what is required is a free society that will not unnecessarily victimize persons, but that is not to be construed to mean that the state cannot put in place certain laws which protect its customs and traditions of the people.
Thank you, Mr. Chairman. That'll be all from my side.
Yes, Honorable Susu.
Thank you very much, Mr. Chairman. Honorable nominee, I would love to find out whether the data bank was involved in the Ejapa royalties deal. Were they one of the advisors?
Yes, Data Bank was jointly appointed with Imara Corporate Company as a transaction advisor.
As a follow-up, given the fact that the then Minister of Finance is strongly associated with Data Bank and is known to be a co-founder and a former director and someone who could be said to have a beneficial interest in Data Bank being appointed as advisor to a transaction like this, don't you think that that may sin against the rules in Article 284? And with the permission of the chair, if I may read, it says that a public officer shall not put himself in a position where his personal interest conflicts or is likely to conflict with the performance of his functions of his office.
Well, Mr. I think so. Certain fundamental facts have to be spelled out. Now, Data Bank was founded or co-founded by Mr. Akinfrata, the former finance minister. Now, Data Bank had been engaged in various transactions, which are matters of public record, involving the government of Ghana. In the 90s, they engaged in a transaction involving Anglo Gold Ashanti and the government of Ghana. In the 2000s, in the President Kufuor era, they engaged in various transactions with the Ministry of Finance as well. In the Mills Mahama administration, they engaged in various transactions with the Ministry of Finance as well, including Eurobond and what have you. Mr. Chairman, the question that necessarily arises is whether the mere appointment of the co-founder of such a company, which has been involved in transactions with the government of Ghana at every material time in the Fourth Republic, is automatically barred from continuing in the performance of its regular functions, just by virtue of the assumption of office of one of the co-founders as the Minister of Finance. The Chairman, that may seem to be a little unreasonable and a far-fetched conclusion to draw. The Chairman, if that were the case, I'm saying so and I'll address the specific matter stemming out of this transaction. Then an Attorney General who also had a law firm before assuming office as Attorney General, would it also imply that such an Attorney General, the law firm of that Attorney General, would also be prohibited from representing any ministry, department, or agency just by virtue of one of the founders of the law firm being an Attorney General? Of course, I don't find myself in that situation. The law firm I founded, Dami and Partners, I put it on hold. Before I got appointed, I was just appointed just around the time I founded. So there's nothing like that at all. So I'm not speaking for myself by making this allusion. But it is a notorious fact that every Attorney General had a law firm before becoming Attorney General. In this transaction, my scrutiny of all the documents, particularly the tender processes, the evaluation of the tender processes, does not show any violation of any aspect of the tender processes. And indeed, I do not see any allegation by any person to that effect. The Chairman, the special prosecutor, then, it would be very important to quote from certain aspects of the report that he himself prepared, which sought to suggest a conflict of interest situation, a finding of conflict of interest situation. Now, the special prosecutor stated at page 3 of the letter that he wrote to the President, the letter dated 16th October 2020 to the President, that the analysis of the risk, start from page 2, the analysis of the risk of corruption and anti-corruption assessment in the bid selection process led to the assessment that the involvement of Imara Corporate Finance Limited of South Africa in the mandate agreement as approved by the PPA made the mandate agreement and transfer business agreement. I've addressed that one already. Then says the slowly, I'm sorry, because I'm reading that one. I'm saying, says the mandate agreement does not say how and when the decoy, Data Bank of Ghana, was to be paid by Imara for a contract reportedly won and performed jointly. This opaque arrangement in the contract and arising after the PPA approval is what made the analysis of the risk of corruption assessment conclude that the process of the selection of the transaction advisors disclosed a reasonable suspicion of bid rigging and corruption activity, including the potential for illicit financial flows and money laundering in the arrangement of how the fees payable to Data Bank as a decoy, which was not approved under the PPA Act, are to be made. Respectfully, we find here very serious and severe conclusions made by the auditor, by the special prosecutor. And Mr. Chairman, these conclusions, with all respect, seem to be suppositions or inferences that the special prosecutor, drew from his assessment, which made the finding that the agreement did not have PPA approval. I've already explained why, in the context of the approval of registered tendering method, the Minister of Finance had the full authority to determine the rules of the tender and to supervise the implementation of the rules of the tender. So, if indeed just by involvement of Data Bank, an allegation can be made that there was a reasonable suspicion, and mind you, with all respect, it is not a conclusion that there was bid rigging. It doesn't conclude so. It says reasonable suspicion of bid rigging. I think that he actually owed a duty to show how the rules set out in the tender processes launched by Data Bank, launched by Minister of Finance, were breached and breached in favor of Data Bank. And he doesn't, with all respect, show how the tender processes, as I've indicated, were breached by Minister of Finance in favor of Data Bank. So that is one problem that I had.
But don't you think...
Then again, he also indicated towards the end that This assessment does not constitute an investigation, even though formal investigations or the suspected commission of corruption and corruption-related offences may arise from this corruption risk. It is not the work of a commission or committee of inquiry. So you find here the same federal prosecutor, after having made all these wild, with all respect to him, somebody because he's a very good friend. I go to his office and he sometimes says that I'm one officer from the Ministry of Justice who visits him regularly. When I used to consult him about a lot of things, he says that it is not an investigation, it's not the work of a committee or a commission of inquiry, but at the same time, there's reasonable suspicion. I think that he really owed, or the office owes a duty to go beyond this report and actually commence an investigation, even and to ascertain whether there was or there was not. Until then, there cannot be an allegation that there was conflict of interest. Now, conflict of interest, again, as is defined in Article 284, is a situation where a public officer places himself in a situation where his personal interest conflicts with the performance of his public functions. The Constitution does not go beyond it to explain or indicate other elements of conflict of interest. Thankfully, SHRAD has come out with certain guidelines for determining whether there's conflict of interest in a situation. And they allude to one, where there's financial interest of the public officer in the transaction in question. Or two, where financial interest can be imputed to other persons who are associated with the public officer. Or three, where the public officer abuses his public office for private profit. Or four, where the public officer abuses public information, i.e., breach of confidentiality and what have you. Then, SHRAD proceeds in the same guidelines to provide two cures of conflict of interest. The first proposed cure is by a disclosure of the interest. And if the committee would note, and it is for this reason why they came up with the findings they did in the ABAJ matter. Secondly, where there has been a removal of the public officer from the transaction in question. Mr. Chairman, as I indicated, because of the lack of clarity with regards to the issue whether indeed by virtue of a public officer having an interest in a company, that company, whenever the public officer assumes office, should be prohibited from engaging in transactions. I think I will recommend law reforms in that regard. I think that there ought to be a passage by this Honorable House of the Code of Conduct of Public Officers Bill. The Code of Conduct of Public Officers Bill has been prepared by the
Honorable
officer. Until
yes,
then, I don't see any conflict of interest.
Yeah, thank you, Mr. Chair. Again, when you look at the corruption risk assessment report on page 56, the last paragraph.
Is that corruption what?
Risk assessment report. The same report that he referred to.
Honorable Matiamidu's risk
56.
assessment report, yes.
On page 56. The last paragraph. This was a conclusion made by the special prosecutor. It says that a deeper analysis of the risk of corruption and anti-corruption assessment of the mandate agreement arising from snowballing by the deputy minister led to the discovery that Honorable Charles Edubwahin, the deputy minister, who appeared from the analysis of the risk of corruption and anti-corruption assessment to have been the overseeing deputy minister for this procurement process for the transaction advisors and purportedly signed the mandate agreement for and on behalf of the Republic of Ghana, knew or ought to have known that he could not commit the Republic to any contract, let alone sign the mandate agreement in the name of the Republic. And he made reference to Section 7 and Section 25.3 and Section 4 and Section 102 of the Public Financial Management Act.
Honorable Member, he has answered and referred to all these things earlier, so you may ask another question, please.
Oh, very well. Very well,
Honorable, so when he was dealing with the capacity question, those were quotes what probably we didn't know was that it's the same quote you are referring to the Martin report, but he was on the capacity issue referred to that.
Very well, Mr. Chair. Now, my second question borders on your role on the PPA board. Were you a member of the board?
Yes, Mr. Chairman, I was. And I think
what was supposed to be your role on that board?
But my role was a member of the board to approve applications in accordance with the provisions of the Public Procurement Act at 663, primarily.
So what would be your response to the concerns that being an institutional rep on that board, you cannot completely extricate yourself from the PPA scandal because you were supposed to be the government's legal advisor on the board?
Right. Okay. Mr. Chairman, yes, I think even though I've answered, I will go to the importance of the question and refer to the ABAJ ruling. And I've indicated that the ABAJ ruling came up with key findings. None of the findings implicated the board in any way. The findings centered around the personal conduct of Mr. ABAJ. And insofar as something he did on the board was concerned, Shad actually found, for an instance, that he even altered the minutes of the board of a particular day. So really, those were personal acts. And Shad indicated for the record at page 176 that the key issue was about the respondent, that is ABAJ, ABAJ's public capacity role as CEO and board member, participating in the decision-making process on applications involving his company. Indeed, the conduct of the board was not an issue before Shad. I've also referred to 7 issues set for determination by Shad. None of them bordered on the conduct of any other board member apart from Mr. ABAJ. And even Shad also, just for the record, held here at page 158. It says, this investigation abounds with evidence of many instances of the respondent, that's Mr. ABAJ, not disclosing or recusing himself during board meetings. And then it says, secondly, we also see for documents, but the point has been made that clearly the investigation was, or the findings were about Mr. ABAJ and not the board. And I will just for the record indicate that the PPA, as was found by Shad, when it engages or approves of a research tendering method, only approves the method. It doesn't engage in a tender. The PPA does not select companies for a tender. It does not evaluate tenders. It doesn't select companies which win a tender. Those are done purely by the entities. And those entities were not the PPA at all.
Mr. Chairman, my last question borders on human rights. Under your watch as a Deputy Minister for Attorney General and Justice, we've had several human rights violations in the country. The first one, I would make reference quickly to some of our students, even though this may be in reference to legal education, but I consider it as a human rights matter, who were given letter from the Ghana School of Law to Rwanda. They managed to finish their legal education. The president was even in Rwanda. There are evidence showing that, assuring them that he was going to do something about their condition, only for them to finish, come back to Ghana, and as we speak now, they cannot be given a post call. That is one of the major human rights matters I would want you to address when you eventually address this matter. Now, in the 2019 Human Rights Report by the United States Department Bureau of Democracy, Human Rights, and Labor, this was what they found as far as human rights is concerned in Ghana. It says that significant human rights issues included arbitrary and unlawful killings by the government or its agents, harsh and life-threatening prison conditions, violence against journalists, including assaults, death threats, and one journalist shot and killed, censorship of a free press, including arrests, and the closure of 2 radio stations for ostensibly licensing irregularities, corruption in all branches of government, crimes of violence against women and girls, to which government negligence significantly contributed, infanticide of children with disabilities, criminalization of same-sex sexual conduct, although nearly enforced, and although barely enforced, enforced child labor. What would be your response, your policy response to some of these major human rights matters that were raised in this report, some of which we also know? We know of a number of police killings. Some of them are under investigation. But what would be your commitment to the fight for human rights in this country when you're given the nod?
Chairman, I respectfully observe that the matters referred to, or the instances cited by my friend, the honorable member, relate to institutional weaknesses as far as I'm concerned. Because the honorable member was talking about violence against journalists, sentencing challenges, child labor, laws, and all that. I mean, these are things that, with all respect, have been there and have been a result of the weaknesses of the Ghanaian society, and I acknowledge same. I think I can only make a firm commitment to the eradication of same. I myself have been a human rights practitioner for about 18 years already. I have many human rights cases on record, as I'm sure my friend already knows. So I can only, yes, but I will just resist the suggesting that it is as a result of our term or the past 4 years, or all these instances occurred in the past 4 years. I do not think that we can say that, or we can attribute these human rights violations to only the past 4 years. They have always been around, child labor and all. Of course, I see that Ghana's record in child labor has not been impressive at all. And I share your concern. There ought to be very urgent measures put in place to ensure a cessation of these human rights abuses. And I commit myself to it. Of course, the law school issue, yes, I've indicated the drafting of a bill that we did. The drafting of the bill occurred, and that represents a very huge bold step to ensuring expansion of access to the law school. The drafting, the legal profession amendment bill, if passed by this House, will ensure that the faculties are empowered to carry out professional legal education themselves, and there will be a mechanism also struck to ensure proper supervision by a General Legal Counsel. And I've already indicated that we can only achieve a synchrony of access to a law school with access to the professional legal education by ensuring that there is a reform of the regulation procedure. It is incongruous to have law school regulated by the General Legal Counsel and a different arrangement, i.e. vesting in the hands of the National Education Board for the regulation of the LLB program. There ought to be harmony between the two means of regulation of legal education.
Very well. Yes, Honorable Bama.
Thank you very much, Honorable Nomi. Congratulations, Honorable Dami. I have 3 questions. One, the Supreme Court recently held in a number of cases that state institutions or entities that the state has interest in, some interest in, be it private or public, may use the services of private legal practitioners to prosecute their cases when they so desire. Notwithstanding that, the office is supposed to be the principal legal advisor to government and to represent the state in such matters. Recently, there was a situation where the Auditor General chose to defend a case using private lawyers. And the Office of the Attorney General also think or thought they should have acted for the Auditor General. To what extent do you agree or disagree with the position of the Supreme Court in this regard? Thank you.
Mr. Chairman, I am aware of the decision of the Supreme Court in Amegache against the Attorney General, and that was way back in 2012 or 2011. I don't know whether it's the same decision my learned friend or honorable member is talking about, the same decision. So I think that's why the Supreme Court did not say that state institutions have the right to engage private lawyers. The Supreme Court rather held that it's only when the interest of the state or interest of government conflicts with that of a particular state institution, that the particular state institution may engage private lawyers. So to start with, public bodies or state institutions are supposed to be represented by the Attorney General. It is the duty of the Attorney General to represent state institutions, and I'm not about, with all respect, to shed away some of my powers. I think that I would still agree that, yes, the Attorney General ought to represent all state institutions. That's the comment. It's only when, as I stated, the interest of the government conflicts with that of an institution of state, say the Electoral Commission. That is why the Electoral Commission has the power to appoint its own lawyers. Or SHAG. That is why SHAG also has the power to appoint its own lawyers. But the specific instance of the Auditor General, yes, I myself was the lead counsel for the Attorney General when the Supreme Court indicated that the Attorney General ought to represent the Auditor General. And that was consistent with the position that I had held. Because the Auditor General is part of the public services of government. Auditor General is a member of the Audit Service, and the Constitution says so clearly. The Audit Service Act also says so clearly. There is thus, with all respect, no warrant or basis for the Auditor General to be hiring its or his private lawyers. If the committee looks at Article 189 Clause 1, as well as Clause 2, it makes this quite clear. So Clause 1 says there shall be an Audit Service Board, which shall consist of A, the chairman, and then the Auditor General, head of civil service. Then Clause 2 says the appointment of officers and other employees in the Audit Service, other than the Auditor General, shall be made by the Audit Service Board. So inherent in this provision is a recognition that the Auditor General is part of the Audit Service. The provision only says that the appointment of other members of the Audit Service, apart from the Auditor General, shall be made by the Audit Service Board. But to make this position quite clear, the Audit Service Act has stated in Section 2, the membership of the Audit Service. Section 2 of the Audit Service Act says members of the service. The members of the service are A, the Auditor General, and B, other persons employed in the service. So, quite clearly, the Auditor General is part of the Audit Service and therefore part of the Public Service of Ghana. Because Article 195 has stated the public services, Article 190, has defined the public services of Ghana to include the Audit Service. So clearly, you see that the Auditor General is supposed to represented by the Attorney General. And that is what the Supreme Court held in, or I think the first day of the hearing of the Professor Asari matter, the matter that Professor Asari had filed challenging the powers of the President to appoint, to ask the Auditor General to proceed on leave. On the first day, the Supreme Court held that I ought to represent the Auditor General. So I think it's quite clear. So perhaps the Attorney General has to boost his or her capacity to employ more lawyers so that he can effectively represent all members of the public service. That is all.
Thank you. My second question, please, can we look at Article 58 and 295, as well as provisions under Article 88 on the office of the Attorney General, which is a creation of the Constitution. See? In 88.1, a dual role is created for you as a Minister of State and the principal legal advisor to the government. And government is also defined under Article 295, I'm sure. You will be Minister of State, God willing. The President is the head of government, and government is defined to mean the executive, I'm sure. The President may have his political interest. You are an appointee of the President. You are going to be the principal legal advisor to the government. To what extent would your obligations to the President and the Constitution come to play should you be required to give a fair opinion on matters affecting the state to the government in that dual position? Thank you.
Mr. Chairman, I think that, yes, I recognize the points made by my learned friend, the honorable member of the House. But Mr. Chairman, again, I would say that an Attorney General ought to act in accordance with the dictates of the Legal Profession Act, the Legal Profession, Professional Rules and of Conduct and Etiquette Rules. And indeed, an Attorney General is supposed to act faithfully to the state. Attorney General is supposed to be the vanguard of the rule of law. He's supposed to be the protector, the first protector of the citizen as well as of the courts of Ghana. And I would say that in my track record, with all humility, will show that I act faithfully and impartially, regardless of political affiliation. And I can cite the case involving an honorable member of this House, Mr. Kennedy Japan, and when he found himself in a situation which bordered on contempt of court, and the Attorney General was ordered by the Supreme Court to defend the judicial service because a justice of the High Court had exercised his powers to cite Mr. Kennedy Japan for contempt. I was called upon to defend the justice of the High Court against Mr. Kennedy Japan, who we know is a leading member of the MPP. The record will show that I actually mounted a defense of the judge's orders citing Mr. Kennedy Japan for contempt. I was not persuaded by the fact that Mr. Kennedy Japan is a leading member of the MPP and also a leading Santa Clausian for that record, for the record. I was not persuaded at all. I defended him and the judge of the High Court against Mr. Kennedy Japan. And I think that is recorded in the judgment of Justice Yoni Kulendi, dated
no, is it Yoni Kulendi, the Justice of the Supreme Court?
Yes, please. Justice Kulendi, Justice of the Supreme Court. In the case of Republic versus High Court, Land Division, Accra, Esparti, Kennedy, in Japan. So when I was called upon to indicate whether the conduct of a leading member of the MPP bordered on contempt, I agree that indeed his conduct bordered on contempt. And so the record we show, page 14 of the judgment, said it was argued for and on behalf of the respondent by the learned Deputy Attorney General on 14th October 2020 during his oral submissions before us that the application was fundamentally misconceived. And that's Mr. Kennedy Japan's application was fundamentally misconceived. As same was predicated on the false assumption that there are different high courts. Then he goes on. The jurisdiction of the High Court vested in the Justice of the High Court includes the power to commit for contempt, as clearly enshrined in Article 126, Clause 2 of the Constitution. There is therefore no doubt that His Lordship, Justice Amos Wuta Uni, had the power to commit for contempt, even though the words in question were allegedly spoken of a different justice of the High Court. He cited the dictum of the Kufuor CJ in the case of the Public vs. Liberty Press to buttress his point. Mr. Chairman, before you is a judgment in which I have, against the interest of a member, leading member of the MPP, defending the administration of justice and all. So I can give that assurance to the court, to the committee, that when appointed, I will faithfully administer justice, irrespective of political affiliation or ethnic origin.
Yes.
Honorable Minister Designate, we all respect you at the bar. To that extent, I've seen the bar president in the chamber to observe proceedings. You are going to be the leader of the bar.
Honorable Member for the Okankwe Central, you know that it is unparliamentary to refer to people in the gallery. So please cut it out.
Very well. I just saw him in the corner, far corner, Mr. Chairman. And you are going to be the leader of the bar. There's been some issues between the bar and the bench, which has led to some lawyers being called before the General Legal Counsel and what have you. What are some of the things you have in mind to bridge that bar-bench relationship when giving the nod? Thank you.
Mr. Chairman, did I tribal manipulation? Is it tribal manipulation? What would I do? I didn't get the tail end of the question.
That you are going to be the leader of the bar. There's some issues between the bench and the bar that lawyers do complain about. As leader of the bar, what are some of the things you are going to introduce to bridge that conflict somehow between the bench and the bar to foster some sanity within the profession? Thank you.
Mr. Chairman, are you talking about the situation where Justice of the Superior Court complain about the conduct of certain lawyers which border on contempt? Right, that's fine. Mr. Chairman, I'm of the view that lawyers ought to abide by the rules of their profession. I am, with all respect, very conservative in my thinking, even though relatively young. And I would want to adhere to the time-honored virtues of the profession. I am also of the view that, yes, judges also ought to act in accordance with the code of their profession, which is to treat lawyers with dignity and respect and to conduct their proceedings fairly and write very sound judgment which can stand the test of time. So I think that, with all respect, harmony can be achieved between the bar and the bench by an adherence by both sides to the dictates of their code. So if a lawyer is to observe the fourfold duty of a lawyer, first, duty to the client, a duty to the court, duty to the profession, a duty to the public. And by ensuring that when cases are pending before court, they do not make unnecessary comments which will prejudice the outcome and which will actually even undermine the foundations of society. I think harmony can be preserved. Secondly, if judges are also exercise their discretion fairly and soundly in accordance with the dictates of justice and the rule of law, the nation will also be better off and will have a sound profession. I don't know if I've answered the value friend.
Thank you very much.
Very well. Yes, Honorable Samuel.
Most grateful, Mr. Chairman. Mr. Chairman, I would have a few preliminary observations on the CV very quickly. It shouldn't take us more than a minute. I have try to reconcile this year's CV with what was presented to us 4 years ago. And I hold in my hands the Hansard of 6 April 2017. I noticed a few matters for our records, accuracy and consistency, and educational background. In 2017, you had an entry for a short course at Oxford, June to October 2006, but that doesn't find expression in the current CV under your educational background. Is there a particular reason for that?
Well, indeed, it does find expression. It finds expression under academic fellowships and awards. I recognize that it was a fellowship by the Open Society Initiative and resulted in the pursuit of the program in comparative law, media law and policy at the Center for Social Legal Studies in Oxford in 2006. I felt that because there was a specific provision for fellowship, I should bring it under that part. So that's what it is.
Thank you very much. At page 5 of your CV, the second entry, your Broja Jemfi versus Attorney General, constitutional challenge to the Military Defense Cooperation Agreement. Should that be the Ghana-US Defense Cooperation Agreement? You do not specify, just for our records. Which defense cooperation agreement would that be?
Yes, Mr. Chairman, indeed, that's true. The Ghana-US Defense Agreement.
I also observed that under leadership positions held, you don't give us a specific start date. You may want to consider that later for our records. And then at page 6, the third entry, do we have your permission to clean that up? The chairman, Greater Accra Regional Football Association, disciplinary committee appears repeated.
That's right, yes, Greater Accra Regional Committee. Yeah, disciplinary committee.
I don't know if you noticed that.
Yes.
April 2008 to February 2009, chairman, Greater Accra Regional Football Association, disciplinary committee.
Yes, Mr. Chairman, I think the last one should not have been there. It was a repetition. This is my committee. Okay.
Thank you very much. I want to begin with my substantive questions. A matter I have been probing since these hearings began. Shall I say famous or infamous airport testing antigen test by Frontier Healthcare Services? So far, my expedition has been quite tortuous and eventful. The health minister tells me he has no idea. He has incited the agreement. The foreign minister designate told us yesterday she was not consulted. You were in the Attorney General's department. Article 88.1 makes you the principal legal advisor to government. Are you aware of this transaction? Did you prefer any legal advice to this transaction?
Mr. Chairman, I was not a principal legal advisor to the government. I was Deputy Attorney General. And my Lord, Mr. Chairman, the duties of a Deputy Attorney General or a Deputy Minister is to assist the Minister on matters that are assigned. Mr. Chairman, I'm not in a position to tell whether indeed it was referred to the Office of Attorney General. Even this afternoon, I've indicated that the Japan transaction, even though I've spoken about it extensively, I was not the one who worked on it. I was not, because the Attorney General assigns work as and how is necessary.
A follow-up on that. It appears my tortuous expedition continues. Fortunately, you were wearing two hats. So if I can't get you with legal principal advice, you served on the governing body of the Public Procurement Authority. Did that transaction come to the board's attention?
Mr. Chairman, readily, on the top of my head, because there are hundreds of approvals that are taken by the PPA every week, hundreds of them. So I cannot tell whether this particular one, and most of the time, because I'm Deputy Attorney General, accompanied with court, when they are sitting around 10 a.m., I will be in court. I will not be there.
Mr. Chairman, I will move to my second question, which will be grounded under Article 296 of the Constitution, which, Mr. Chairman, I read. Where in this Constitution or in any other law discretionary power is vested in any person or authority, A, that discretionary power shall be deemed to imply a duty to be fair and candid. B, the exercise of the discretionary power shall not be arbitrary, capricious, or biased, either by resentment, prejudice, or personal dislike, and shall be in accordance with due process of law. You assisted the respected Attorney General, the Honorable Gloria Akufu. There are two discretionary matters I want to present to you today to explain to us why you exercise that discretion in that manner. The first one is the Aisha Huang matter, which you filed a nolle prosequi and decided not to pursue that matter. At the time, the president had declared war on Galamsey, which continues to wreak havoc and is really an existential threat. We will not have water in the next few years. Already Ghana Water Company is saying they are processing below 40% because of Galamsey. At the time that Ghana was giving Aisha Huang a free passage back to China with roses, the Ivory Queen in Tanzania was jailed 15 years. Your counterparts in the Attorney General's Department in Tanzania jailed the so-called Ivory Queen, as she was known. Yang Feng Lang is her name, for 15 years for exporting elephant tusks. In Ghana, despite the president's war on Galamsey, you exercise that discretion to give Aisha Huang a free and safe passage. The second matter of discretion I take issue with is one of our colleagues, a former colleague of this House, senior colleague of this House for that matter, the Honorable Inusaf Hussein, who in the exercise of his free speech after the election said that in his personal view, if he was President Mahama, he would have declared himself winner and announced a government. As we speak, you are prosecuting Inusaf Husseini under Section 207 of the Criminal and Other Offences Act 1960 Act 29. You have charged him for what you say is, or what the law says is a breach of an offensive conduct conducive to breaches of peace, if I'm to be specific. At that same time, another member of this House, the Honorable Kennedy Ejepong, publicly stated, which was widely reported, and actually threatened to burn down the house of our flag bearer and former President, His Excellency John Dramani Mahama, and the house of Bevlolate, Asiedu Nketia, and other NDC bigwigs. Unlike Inusaf Husseini, he's not being invited, he's not being prosecuted. Are you not exercising your discretion in a whimsical, capricious, and arbitrary manner, contrary to Article 296B of the Constitution of Ghana, on these two matters?
I'll be very grateful to know the date on which the prosecution of Mr. Inusaf Husseini commenced.
Inusaf Husseini tells me his next court appearance is the 22nd of February.
No, when the prosecution was commenced.
I would have to check that. I would have to check that.
I was inquiring about this because my term as Deputy Attorney General lapsed on 6 January 2021. and after 2021, I ceased with Deputy Attorney General. To date, I have no lawful mandate in the office, and therefore I could not have been involved in the prosecution of Nis Afisenu. My former boss, Madam Gwekufu, also the same. The term lapsed on that day. Perhaps the prosecution is being done by the police. I wouldn't know. Now, regarding Aisha 1, Mr. Chairman, that was a discretion exercise by the Attorney General. Attorney General has powers under the...
I'm sorry, Mr. Chairman, if you permit me. Before you move to Aisha 1, what is your view on these two matters moving forward, if given the nod?
Mr. Chairman, I will have to examine the facts of the matter. I have not had the opportunity. These facts have not come to my attention. That's why I even asked about the date. And I've not been in the office since so.
You can proceed to Aisha 1, please.
So Aisha 1, the discretion was exercised pursuant to the entry of a nolle prosequi. And we know the nolle prosequi is entered pursuant to the Criminal Procedure Act, as well as the constitutional powers of the Attorney General to control the conduct of criminal prosecution in the country. Mr. Chairman, the Supreme Court has held in Gregory Afuku versus Attorney General that the powers of the Attorney General to enter nolle prosequi is not questionable, cannot be proved by anybody, including the court of Ghana. And for that matter, I do not know.
Within the courts of Ghana, what about here, Parliament? If we are interested, we will ask you, why did you exercise that power?
No, yes, that's right, but I was not the Attorney General. The point I was coming to is I was not the Attorney General. So only with all respect, my former boss, Madam Gwekufu, would know, and indeed she is not bound, as I said, even to disclose it to the court. And so that the reason for the entry of nolle prosequi has not been published, and I already know why.
I want to come to the third matter of interest to me, which is fighting corruption. Corruption is a canker, very destructive, very corrosive. It destroys every facet of society. You have spoken extensively to exonerate yourself on the ABA-AJ PPA scandal. Are you telling this committee, and Parliament for that matter, that the governing board has no role in preventing corruption, and that it had to take a lowly journalist who doesn't have all the powers of state, all the resources that we give board members to protect the public purse? A lowly Manasseh Azuri Awuni discovered this gross act of corruption. Are you telling us that as a board, you had absolutely no role in preventing this heist which took place?
Mr. Chairman, I am not seeking to exonerate myself from anything at all, because my conduct has never been the subject matter of any query, scrutiny, or investigation by anybody. And as I've indicated, the record available to me, which I can make available to the committee as well, the ruling of the Commission on Human Rights and Administrative Justice in the ABAJ matter, will show that it was a personal conduct of Mr. ABAJ, which was the site matter of investigations. And SHAT came to findings, the key findings, none of them borders on or impugns the conduct of the board, or including me myself. Mr. Chairman, I would have to clarify that, yes, the role of the board under sections 38 and 40 of the PPA Act is to approve of applications for research tendering and single sourcing. Mr. Chairman, that approval, especially for research tendering, as I've indicated, is an approval for the entity to go and commence a process of tender. The only reason why the entities have to come to PPA for approval is that it is restricted tendering. By restricted tendering, it is limited to entities selected by the procurement entities themselves. And so the PPA will determine whether there are grounds for the entities to engage in restricted tendering. When such approval is given, the entities, as I've indicated, pursuant to Section 39, will commence a process of restricted tendering. And all the rules of competitive tender, apart from a particular section, because it's not competitive, will apply. That is why I say Section 39 is very important. Now, Mr. Chairman, Manasseh Awuni will even indicate to you that the very first time I got to was when he himself called me on phone after the investigation and stated that it's because of, with all respect and all humility, how the little respect that he had for me. And he knew that I knew absolutely nothing about it. And indeed, that issue even came to his own attention in the course of an interview he had elicited of Mr. ABJ, which was unrelated to the matters that he had notified Mr. ABJ about. And then the gentleman himself, Mr. ABJ, volunteered such information. That is how he got to know. And subsequently, when he got to know, and he came up with this, in fact, I think the Saturday before he came up with this report was when he called me to inform me that, oh, he thought out of respect to me because he respected me so much, and I've assisted him on numerous occasions by giving information freely, matter of public record. He felt it right to inform me.
So, Mr. Dame, you don't think that Section 4 of Act 914, which says the board shall ensure the proper and effective performance of the functions of the authority, together with Section 3D, functions of the board, monitor and supervise public procurement and ensure compliance with statutory requirements. You don't think the board check its responsibilities pursuant to these provisions of the Act?
No, Mr. Chairman, yes, monitoring of public procurement includes ensuring whether entities who have been given approval by the PPA have complied with what the law requires them to do. We're talking about a situation where ASRAD itself noted Mr. ABJ did not disclose his interest in certain companies, and that clearly was a conflict of interest. We're also talking about a situation where ASRAD noted, according to ASRAD, certain letters, 30 minutes, of the board were altered by Mr. ABJ. Such a circumstance, how can it amount to a violation of the rule of the board in Section 4, monitoring transactions? But it's also important to indicate that the conduct, this report, the site matter of a challenge by Mr. ABJ in the court of Ghana, and therefore we must, with all respect, have regard to say,
well, I believe as public officers, we can hold ourselves to much higher standards than that. Finally, from me, under corruption, is the Ameri matter. The president submitted to this House an executive approval under his hand.
Yes.
We were later told in a Daily Statesman report that the president was misled. Could it be that it was the principal legal advisors, the Attorney General's department, that misled the president?
Mr. Chairman, I am not aware of such a situation, the Attorney General misleading the president in any way at all. I'm rather aware of an opinion of the Attorney General indicating that there were no grounds for termination of the agreement. And subsequently, I'm also aware of a revision, if I may say, of the agreement by the Minister of Energy, whereby savings in the sum of about $57 million was made. Those are the facts that are available to me. And that resulted in the innovation agreement.
Honorable Ablekuma, Central, or no, West. Why do I always confuse you with Central?
Mr. Chairman, you keep assigning other constituencies to me. It's Ablekuma West.
My apologies.
The good people won't be very happy with us. Mr. Nominee, congratulations on your nomination. If confirmed, you would be the youngest Attorney General in our history and the leader of the bar. Do you think that, excuse me? I said he would be the youngest Attorney General in the history of this country. Do you think that that would be an inhibition or on your performance in view of the fact that you would have several seniors that you would have to superintend over? And how are you going to manage in view of this perceived challenge to, or would-be challenge to your authority?
Everyone, I'm very grateful for the question. Everyone, I may be young, but I think the records also show that in 1966, when Mr. Victor Wish was appointed as Attorney General, he was about 43 or 44 years. And Mr. Jogati, when he was appointed Attorney General, was about 45 years. Then, Mr. Chairman, again, Kwame Nkrumah's Attorney General, Mr. Koswanzi, was also 41 years, but just, I think I beat him just a few months, so respect. Mr. Chairman, even the immediate past Attorney General of the United States of America, Mr. William Barr, I think the records show that this was his second term as Attorney General. The very first time he became Attorney General was in George H.W. Bush Sr.'s era, in 1991. I think he was about 39 years only when he was appointed as Attorney General of the United States of America. The Chairman, apart from that, yes, as Deputy Attorney General, I had the experience of also working with the same seniors at the bar, at the Attorney General's office, and I think that on many occasions I actually, in all humility, supervise their work and I did so efficiently. I think having served as Deputy Attorney General for 4 years, I've had enough opportunity to learn, and of course, I only have to act in accordance with the dictates of professionalism, and I'm sure with God be my guide and the help of this honorable court, House as usual, I will succeed.
Thank you, Mr. Chairman. We're living in interesting times currently with the election petition currently ongoing. We've seen that during the period of the 2013 election petition as well, the Supreme Court came down pretty heavily on people who commented, in their opinion, wrongly about some of the matters appearing before the court at the time, and exercised their right to punish for contempt. We've heard some pretty interesting comments being made currently about the proceedings in the court. In your view, should the Supreme Court exercise its power to commit for contempt in this current situation? Or what do you think about this general exercise of this power of the court?
Thank you, Mr. Chairman. I think that on this issue, I'll be guided by the words of Akufo-Addo CJ in the Republic versus Liberty Press, that said justice is a closet virtue, but of course, judges, they don't live in cloisters. The point is that administration of justice is very essential to the functioning of society, and therefore, the courts play a crucial role. It is of absolute necessity that the sanctity and integrity of the judicial process ought to be preserved at all times by all role players, especially lawyers. And I think that lawyers, if we destroy our profession, there will be nothing for us to go back to. And for that matter, it's important that lawyers become the very first defenders or very first people who ensure that the streams of justice flow and flow unimpeded without unnecessary comment and interference by way of comments that they make. And so, again, it is also important that the judiciary, even though they are vested with the powers of contempt, also have regard for the fact that the judgments and orders that they make will become the subject matter of interest and discussion in the media and the public space. And for that matter, the exercise of powers of contempt ought to be made only sparingly. So I think there ought to be a fine balance. As I always say, yes, we all must have respect for our respective roles. And so if the public, especially lawyers, recognize that when the streams of justice are flowing, they ought to flow without any unnecessary interference in them, there will be few instances of applications for contempt or the court exercising its powers to cite them for contempt. And the judiciary also, yes, it must also be only in cases of seriousness, whereby comments clearly have interfered with the office of justice, that they exercise their powers of contempt. And in this, I think I should also deplore the attitude of certain lawyers when cases are going on, they go and make certain judgmental comments about the matters, and also seek to denigrate the integrity of the court. I think that is very bad. And if such, I will not hesitate at all to exercise my powers with all respect, as Attorney General when confirmed, to cite them for contempt. And the record will show that I will not do so at all, and I will do so in appropriate cases.
My final question would be that, having been in the Office of the Attorney General for the past 4 years, I'm sure you're very well aware of the challenges that state attorneys encounter in the course of their duties. And I'm not sure if the staffing situation has improved, but a perennial issue was the numbers of state attorneys available to do the volumes of work that ended up on your table, and the conditions under which they had to work. Has it changed since you got there? Have you worked to, has something been done to improve the conditions of service of the state attorneys? And what would you do to attract more young lawyers to take up professions in the public service and help improve the human resource capacity of the service and thereby enhance your own efficiency and effectiveness?
Well, Mr. Chairman, I am happy to say that indeed the conditions have improved, but of course not satisfactorily. Conditions have improved because the past 4 years, under the leadership of Madam Godfred, 110 state attorneys were employed. And that represented a very huge addition to the number of state attorneys. 2018, 60 were employed, and then 2018, 60 were employed. In 2020, another 50 were also employed, making 110. The current staff strength is 226. 226 is just about the number of an average law firm in the United Kingdom. In the United States, you even have thousands of lawyers. And I think if the Attorney General is to exercise her constitutional functions of being the principal legal advisor to government, which includes ministries, but I will work effectively with the Minister for Finance to ensure that there is a release of funds for the recruitment of maybe even 500 more lawyers, so that we can measure up to the demands of Article 88. Secondly, in terms of facilities, yes, there was the acquisition of 36 vehicles over the past 4 years, and that was also a significant boost. But the 36 vehicles, with all respect, still not enough. We find situations where state attorneys have to travel to Insawam to negotiate, to deal with the concerns of inmates at the prison, and also to undertake this Justice for All programs, not having vehicles at all. Physical space is a major problem. There is even a lack of sufficient desks, common desks for the attorneys to work on. It's even a problem. Meanwhile, during the term of His Excellency the President as Attorney General, there was a commencement of a law house project. I think Madam Honorable Member, Madam was in the office at that time. So the law house was commenced after the President left with successive Attorney General. The law house is uncompleted. There is an urgent and pressing need to ensure a completion of the law house. I think when the law house is completed, it will go a long way to providing better office space for the lawyers and the attorney general's office in Accra. Around the country, there is a need to set up offices. In fact, offices have been set up already, but there's a need to provide office accommodation for all the lawyers in the existing regions of Ghana. Very good.
Yes, Mr. Jerry.
Thank you very much, Mr. Chairman. Honorable nominee. Mr. Chairman, before I ask my questions, I think my question on the JAPA has been answered, except to put on record for academic health that the powers of the special prosecutor in looking at the JAPA transaction was pursuant to Section 2C, 4, 29, 69, 73 of the Office of Special Prosecutor Act 2017, Act 595, and Regulation 31 of LI 2374. That's it. Then I move to my question, which is a follow-up to that of Honorable Ahi. He was worried that the white paper of Emil Short Commission rejected some of the recommendations of the commission. I am interested in the one that government admitted to do. So if you look at page 23 on compensation, the government agreed to compensate the persons mentioned in page 59, paragraph 9.1, and they are Theophilus Sedofu, Seidu James Mohammed Ishahu. The president asked that the Attorney General, because there was no assessment of their injuries, the Attorney General look at it and make sure that compensations are paid to them. Can you tell me the status of this? Thank you.
Chairman, I think the difficulty I find myself in is that I was Deputy Attorney General, I'm not the Attorney General. But of course, I will indicate that, yes, the challenge that perhaps the Attorney General faced was a clear indication of the extent of injury and the quantum payable. So it rendered it then incapable of a determination, but of course the Attorney General had to assess. I don't think that assessment has been done. I think that, yes, we can perhaps look at the provisions of the Civil Liability Act. It's an old Act 1963, Civil Liability Act of 1963, which provides mechanisms for determination of compensation payable in case of injury, fatal injuries, and what have you. So I can make a commitment to this House that if granted, if approved by the House, I will ensure an implementation of this recommendation. Otherwise, the state will find itself in what is anticipated by Article 293, the claim against the government. That where a claim is against the government, then the government will be perceived to be like an ordinary person, and that person can go to court. We do not want that at all. Thank you.
Okay, so a follow-up on that one. There was also needless shooting in Techima South on 8th of January, which caused the death of some young people. Will you also like to advise for a commission of inquiry to be set to investigate properly what led to the shooting, with the assurance that these needless shooting will not happen again? I'm sure that will go a long way in promoting the security health of the people in Techima.
Oh, Mr. Chairman, clearly, 8th January, I was not in government. I will have to first be in government before I examine the circumstances of the matter being alluded to by the honorable member. And of course, we will see whether it will not be, as I said, the Attorney General came to this house in 2011, July, after the Atua incident. Or perhaps the President will be advised on that, on the formation of a commission of inquiry. So, Mr. Chairman, I'll be happy to first find myself in the office before I can effectively take any action on the issue.
When you were vetted 4 years ago, the question of legal education came up. We are all minded of the kind of lawyers we churn out. We are all looking for quality. You indicated that there is a law village that was being proposed and that you are going to assist your minister to ensure that some monies are released for the construction of that law village to enhance legal education. Can you tell us the status of that project?
Mr. Chairman, yes, the law village has been earmarked to be constructed for about 15 years now. It's been there. Unfortunately, I was not a member of the General Legal Council during the 4 years. But I remember members of the General Legal Council I think the Chief Justice himself told this Honorable Court about even a plan, this Honorable House, I'm sorry, Chief Justice during his appearance before the committee told this Honorable House of a planned expansion of the law school by the allocation of a facility around the IPS, now it's University of Professional Studies, I'm sorry, around that university to accommodate about 1,000 students even last year. Unfortunately, we all know the results that emanated from the examination. So, but the law village, as far as I know, is still on the drawing board, has not been done, and I would ensure that it is done. I think it must be done in order to provide additional space for the law school.
Okay, then finally, but take note, Honorable Nominee, that this is the second time we are talking about the law village, and we want you to really pursue it.
Mr. Chairman, I will. The reason why I couldn't do so, I was not a member of the General Legal Council.
Okay. So the last one.
How many
Legal
last ones
aid.
do you want to have?
No, I've asked 2 and a follow-up, so this is my last final.
You said my last one.
Okay, so my last one is on legal aid. How do you, if you are giving the nod, how do you hope to improve legal aid service in Ghana? I give Techiman, Bono East as an example. There is only one legal aid officer for the whole region, and I'm sure throughout the country, you know that we don't have a lot of legal aid officers. How do you hope to improve legal aid? Because it's really of a great concern.
Mr. Chairman, I am happy to state that since my appearance before the committee last time, 2017, there has been a dramatic reform of the legal aid system in Ghana. There has been the enactment of the Legal Aid Commission Act at 977. At 977 has restructured legal aid scheme in Ghana. So Legal Aid Commission has been set up as independent, and it has the capacity to employ and to employ more. In fact, since the passage of Act 977 by this House in 2018 and the subsequent assent of same into law by the President, the Legal Aid Commission has been able to open about 11 district offices, 11 more district offices. And the structure has been improved to even vest it with the capacity to engage in alternative dispute resolution. And it also has an office which collaborates with other agencies involved in legal aid outside the country, so that if a Ghanaian person has a case abroad, a Ghanaian citizen has a case abroad, and that person requires services in the nature of legal aid, the legal aid office is able to collaborate with its counterpart office abroad for the provision of that service. So legal aid has actually been dramatically improved, and I'm very happy that it has turned out this way, and I will assist the Legal Aid Commission to effectively discharge its functions under Act 977 when approved by this Honorable House, or if approved by this Honorable House.
Thank you, Mr. Chairman, but there is room for improvement in respect of legal aid.
I'm sorry.
Yes, I will see.
There's room for improvement.
Thank you very much, Mr. Chairman. Mr. Chairman, I wish to ask a different question related to a matter that has variously been dealt with through questions from, I think, Honorable Obia Amwa and some of my colleagues. But, Mr. Chairman, before I proceed, I just also will want the nominee to avert his mind to the Corporate Governance Manual for Governing Boards, Councils of the Ghana Public Service, which, among other things, lists the responsibilities and duties and liabilities of boards. Maybe let me just share this part that talks about evaluation. The Board Council shall, on annual basis, assess its performance and effectiveness as a team and that of individual members, including the Chief Executive Officer. That emphasis is mine. I just want him to note that. And also his reference to the Shraj report. Maybe it will be useful for the nominee to also be reminded that it is not the final report. And as far as this matter is concerned, and GII, Ghana Integrity Initiative, has actually also petitioned Shraj, and they are working on the possible liabilities of the board. And perhaps maybe it is when that report comes out that he can hold himself and other colleagues exonerated. But, Mr. Chairman, globally, it is known that public procurement is one of government's activities that is most vulnerable to corruption. Public procurement. In Ghana, like we have all been talking about, we heard of the case of PPA. And as part of the Shraj reports, it is stated, quote, the respondent being the CEO of PPA, the regulator of the procurement sector, the Commission is of the strong considered view that he has gravely abused his high office of trust, and the appropriateness and proportionality of any action to be taken by the Commission must be commensurate with the gravity of the abuse. Now, you were on that board of PPA at the time this scandal happened, and Ghanaians expect prosecution and justice from its Attorney General. And perhaps in answering this question that I'm about to ask, the nominee will also want to look at Article 78.3 and the possible spirit behind 78.3b, which says, Mr. Chairman, with your permission, I quote, a Minister of State shall not hold any other office or profit or emolument, whether private or public, and whether directly or indirectly, unless otherwise permitted by the Speaker, acting on the recommendations of a Committee of Parliament on the ground B, that no conflict of interest arises or should arise as a result of the Minister holding that office. Now, the Attorney General, also under 88.3, is supposed to be responsible for the initiation and conduct of all prosecutions of criminal offenses. Now, you have been nominated to be passed as Ghana's Attorney General, having in mind that globally, public procurement is one of government's activities that is most vulnerable to corruption. And even you yourself have stated here that in a day, that entity that you were a board member approves over 100, contracts, or if you like, tender processes that come to them. What assurance can you give us that in your role as the initiator of all prosecutions of criminal offenses, a conflict of interest situation will not arise?
Assurance that in my role as minister, I will not be in conflict of interest.
in your role as Minister for Attorney General, given the role you previously performed, where many procurements were done, some haven't been found according to SHRAG to have, if those come up for prosecution, will you not agree with me that a conflict of interest situation may arise? And given this experience, will you recommend that perhaps Attorney General and ministers, should not serve on some of these boards?
Well, Chairman, just a couple of corrections to make before I answer the question. First, the Ghana Integrity Initiative complaint was not about conflict of interest. It's about a failure or a possible failure of some members of the board to declare assets. So that is being investigated. Declaration of assets. Mr. Chairman, at all my times, I've declared my assets. I declared my assets on assumption of office in 2017. I declared my assets right after my term of office lapsed. I have a copy here I can give to the committee. So I've always been in compliance with the law. That is why I say that I'm not in any fear at all, even though the Ghana Integrity Initiative report has not come out. Second, yes, I said 100 applications a week, not 100 applications per day. And the applications are not tender processes.
Thank you.
They are applications to engage in the procurement method. So the applications for procurement method, not applications for a tender, not at all. Now, Article 78.3, yes, anticipates that public officers shall not hold any other office of profit. And indeed, that Chairman, I've not held any other office for profit all my life. I mean, as a public servant, when I've been a public officer, I've never held any other office for profit. And that's why I indicated that even though I formed a law firm, I think in January, February 2017, once I got to know that I incorporated a law firm. Once I got to know that I was going to be Deputy Attorney General, I never registered a chamber. The chamber is there. Most Attorney General, Deputy Attorney General have always had chambers. I have not had any chamber, just because of possible conflict of interest. Now, secondly, I think that it is of utmost necessity that the Public Procurement Authority Board will have a representation of the Attorney General. The representation of the Attorney General on boards, or public boards, if I may say, is not only in relation to the PPA. Attorney General has representation on many boards, from NHIS to the PPA. I mean, all manner, whether defense, health, finance, security, the Attorney General is represented there. Because that is to guide, it is actually a way of guiding. And the PPA board, in fact, even my record, it actually ascertained on the PPA. They will indicate to you how I've, on crucial occasions, guided the board legally. And that is why, apart from the conduct in question, no other member perhaps has found himself in any conflict of interest. So, the Chairman, I will say that contrary to the view of the Honorable Member, the Attorney General ought to have a representation on the board.
Well, thank you. Maybe you have to look at 78.3 again. It talks about private or public, not only private. You responded to the private part, but that's fine. We can move on. It's also instructive that a while ago, in answering a question, you made reference to a letter that quoted the wrong portions of the Act when I think the leader on our side engaged you, and it's instructive that you were guiding them as you suggested. But to my next question, as Deputy Attorney General, you supported and led government's revocation of the mining leases of Exton Quebec Group Limited in court. Now, the central plank of government's case, which you led, was that Exton Quebec Group Limited leases had not been ratified by Parliament, and they had no right. My colleague and I, Honorable Member for Ashama, identified and filed against 35 mining companies that were carrying out mining in Ghana with leases that were not ratified through our lawyers. We filed this. 2 years on, the case hasn't been called. Now, Honorable Nominee, given these facts known to you and government apparent disinterest on the operations of these other companies and our suit against these companies, how do you convince this committee and the people of Ghana that you were not being vexatious, impartial, and capricious in your strict application of the law on Exxon Cubic Group Limited, and whether on that basis you can be trusted to be a fair Attorney General for Ghana, given the provision of Article 296 of the 1992 Constitution?
Right. Mr. Chairman, I defended the Exxon Cubic matter. Gentlemen, sorry. Gentlemen, so the Attorney General is supposed to be a defendant in all civil cases involving the government under Article 88(3). The Chairman, consistent with this duty, I defended the application filed by Exxon Cubic. And I say I defended, I mean as a defendant, I pursued it vigorously. In the same way, I defended the suit that my good friend, the Honorable Member, also filed. And I do not know why I filed a similar case. I'm sure my good friend has received it. I filed a defense, formal defense, your action. I cannot explain why the Supreme Court has not listed it for hearing. The only point I can make is that the point that my good friend sought to make in that case has already been determined by the Supreme Court in the Ndebugui matter. The Ndebugui matter, even before I assumed office as Attorney General, had held that Article 268 enjoined every mining lease to receive parliamentary ratification. And the absence of parliamentary ratification, a mining lease is invalid. That is clearly the import of Article 268 when it says that every mining lease shall be subject to parliamentary ratification. Subject to is indicating or is indicative of the fact that until the happening of that event, it has not become valid. So that's the position I took also in the Exxon Cubic matter. But beyond that, I also recognize various statutory infractions engaged in the processes leading up to the grant of the mining leases. It was not a simple case of the absence of parliamentary ratification, which led to the filing of my opposition to the application that had been filed by Exxon Cubic at the High Court first. I raised various statutory infractions and violations engaged in the processes, that there was the failure to gazette the mining lease in accordance with laws, there was a failure to give the relevant notices to all the traditional authorities and what have you. And of course, the Supreme Court, in its judgment, noted the statutory infractions in addition to the constitutional violations that characterize the grant of the mining leases. And I think that that's the most faithful way an Attorney General ought to discharge his or her functions, that when assets of the nation had been, with all respect, appropriated or allocated to a company in violation of the statutes of Ghana, in violation of the Constitution, the Attorney General should be the first person to take action. And I was not even the first person. The company sued and I defended. And when the ruling, I did not appreciate the ruling, I went to the Supreme Court and the Supreme Court quashed the High Court's judgment.
Well, Mr. Chairman, I think the nominee didn't address my question of vexatious and capricious use under Article 296. It is not about whether Exxon Cubic was right or wrong. It's about the fact that there were other 35 mining companies operating at the time with, if you like to call them defects, similar defects, which was overlooked. That is the point that I sought to make with my question, which hasn't been addressed. And whether that does not qualify for one to wonder if we will have a fair Attorney General. But I will move on, Mr. Chairman, to my next question.
If you permit me to clarify.
Okay, I mean, if the chairman allows.
The chairman, yes, the 35 mining leases now is bringing in as an element in his question. The chairman, the point I'm making is that, yes, just like Estin Kubik, I again exercise my duties fairly by filing a defense to your suit. The suit is still pending in the Supreme Court. The Supreme Court is yet to make a determination of it. I do not think that we can, in all fairness, make suggestions that the mining leases in question had lapsed and that the government of Ghana is condoning them at all. I will not even do that at all.
Follow up to the answer. You follow up from the answer, not his question.
Thank you. So, Honorable Attorney General designate, if I got my colleague's question correctly, his suggestion was that you had been vexatious. That is to mean that in initiating an action, your response was not clear. Is it the case that in the Exton Cubic, you initiated the action? Because I think the basis of his question was that there are others who violated the law, but they were in operation and you didn't initiate an action in court against them. So he's suggesting that you were vexatious in that sense by singling them out. Is it the case that you were the one who initiated the action in court?
No, Mr. Chairman, definitely not. I was not the one who instituted the action in court. The action was instituted originally by Estin Kubik in protest against the determination by the then Minister for Energy that 8 leases were of no effect. Then I defended the action, and the ruling the High Court judge initially heard recognized the statutory violations and infractions that I had alleged. The High Court judge upheld those violations, that upheld the claim of those violations. But then in its conclusion, the judgment quashed the letter written by the Minister for Energy. In the face of this, I proceeded to the Supreme Court that the judgment given by the High Court was actually in excess of its jurisdiction. The Supreme Court upheld my contention and further affirmed the statutory violations and breaches engaged in the processes leading to the grant of the leases. And I'm saying that in respect of the 35 mining leases, the same situation applied. We defended the action that had been filed by Honorable Suhini together with other people. The action is still pending in the Supreme Court. The Supreme Court is there to make a determination on the matter.
Chairman, just one other follow-up. In your answer to the Honorable Suhini, you sought to rely on the Supreme Court ruling on Indebugri, as you referred to it in Article 268, which deals with ratification of mineral rights and contracts. Are you suggesting, by inference, that those 35 other mining companies are operating in violation of the Constitution per the ruling of the Ndaburi case?
Mr. Chairman, indeed, if the honorable member will recollect, our defense in the matter that he filed raised constitutional issues about the propriety of his action. Mr. Chairman, I have not examined the specific facts and circumstances of each of the mining leases that were alleged to be non-compliant with Article 268. The action itself did not raise sufficient constitutional issues warranting the invocation of the Supreme Court's jurisdiction. And that constitutes a defense that the Attorney General can mount. Indeed, the Attorney General raised that as a preliminary point, and that preliminary point is yet to be determined.
Yes, please continue.
All right, to my third question now. Honorable nominee, I came across a very interesting article entitled Dying for Justice, edited by Hamid Athwal and Jenny Bond, and a foreword written by Colin Prescott, who is chair of the Institute of Race Relations, caught my attention. The first sentence: first, you are wrong, and then you are wrong-footed. The process and procedures for getting justice are all smoke and mirrors, quote and unquote. First, you are wrong, and then you are wrong-footed. The process and procedures for getting justice are all smoke and mirrors. When I saw this, Gregory Afoko came to mind, and then recent developments came to mind. Now, in the context of our justice system, which has been variously, through research, described as slow, corrupt, and sometimes biased, what will you say about this quote as it relates to justice delivery in Ghana, and how you will contribute to perhaps improve what the case is?
The case of Gege Afuku must be looked at within the peculiar facts of the matter. Now, the gentleman was arrested and tried for murder. The police docket indicated that there were two persons who should have stood trial for the charge of murder. The other gentleman had absconded from the jurisdiction, so the trial proceeded against Gregory Afoko alone. Mr. Chairman, the trial proceeded, and then about 2 or 3 years down the line, it was found, the gentleman was arrested in Cote d'Ivoire and brought into the country. Mr. Chairman, in order to prevent a compromise of the evidence, a distraction of the evidence, and thereby a failure of justice, the Attorney General, in exercise of her right to enter a nolle prosequi and to control criminal proceedings, proceeded to enter nolle prosequi in the first trial of Gregory Afoko. It was that decision which led to Gregory Afoko actually proceeding to the Supreme Court, and which resulted in the judgment that I earlier on referred to, that the Attorney General's power to enter nolle prosequi has been upheld by the Supreme Court and has been held to be unquestionable. Mr. Chairman, when the nolle prosequi was entered, necessarily, yes, a fresh proceedings for a retrial of both Gregory Afoko and the gentleman who had been arrested in Cote d'Ivoire commenced. Mr. Chairman, Mr. Afoko then filed applications for bail in between the period that the nolle prosequi was entered and the period that the new trial began. He filed applications for bail. The High Court indeed granted one of the applications for bail. Mr. Chairman, after bail is granted, there is a statutory process for a satisfaction of the conditions regarding the grant of bail. So it is not just a simple case of a person having been granted bail, which will entitle that person to just walk free from the cells of prison. Mr. Afoko, unfortunately, struggled to meet the terms of the bill. Indeed, the record will show that the High Court, he was brought to registry numerous times and the bill was not satisfied. The chairman, subsequently, as I indicated, the fresh prosecution began. And then he was arraigned before the court. Having been arraigned before the court, the new judge exercised a discretion to keep Mr. Afoko together with the new gentleman who had been arrested in custody. And that is what happened. And the trial is going on. It's a jury trial. I believe that will be sufficient for the committee. And then also, regarding the quotation you quoted, yes, I also counter it with the fact that, the right to swing your arm ends where my nose begins. And I think that in the recognition and enforcement of human rights, it's important to have this in mind. That is why the people of SAL, with all respect, I find their case a little bit unfortunate. Yes, they have the right to vote, but the right to vote must be exercised within the confines of the law, and that is, as I said, in poem, termed by law. Therefore, even though they have the right to vote, they didn't have the right to also stop the people of Ohoi from enjoying the exercise of their franchise and by having their member of parliament sworn in. So the right to swing your arm or to swing your fist also ends where my nose begins. That's it, man.
All right. It's interesting you have introduced Sal. My last question.
A
last follow-up, please.
You have had so many lads already.
Oh, just a follow-up, Mr. Chairman. In fact, this is even my fault.
Okay.
Thank you. You introduced Sal. I wish I had more time. I had another opportunity to discuss that with you. But I will end with a follow-up to some answers that you gave earlier. I have in my hand a letter dated 25th January 2019, addressed to the Honorable Minister of Finance, Mr. Ken Oforiatta, titled RE Suit Number CMRPC /0624/2018, Nia Manu Dodo versus Dr. Kobna Dufour and 16 others. Notice of intention to join the Attorney General. Preliminary observations and requests for comment. Now, I'll just go through some few portions of it with the permission of the Chairman. We have examined all the processes and documents so far filed by the various parties in the matter, as well as the documents received from Bank of Ghana, and find the following facts as irrefutable and fundamental to an opinion on the legal issues arising in the suit. Then the facts that you consider irrefutable are listed. I will not want to go through all of those facts for purpose of time. But here it says, from the decisions taken by the Bank of Ghana on 1st August 2018, it is apparent that the mandatory duties of a receiver, such as publication and registration of notice of receivership, and taking of an inventory of the assets and property of Unibank, and publication of same in 2 daily newspapers of national circulation were not done before the receiver entered into the purchase and assumption transaction with CBG. And then finally, we note that CBG was incorporated on 1st August 2018, and a certificate to commence business was issued to that bank on 2nd August 2018. We also observe that selected assets and liabilities of the 5 banks were transferred to CBG on 1st August 2018 via purchase and assumption transaction before the grant of a certificate to commence business. Section 27 of the Companies Act 1963, Act 179, prohibits a company incorporated in Ghana from transacting a business until it has satisfied the provisions therein and has been issued with a certificate to commence business. A violation of this provision constitutes a criminal offense for which the company and every officer of the company shall suffer a penalty prescribed by Section 29 of Act 179. The transfer of selected assets and liabilities of Unibank on 1st August 2018 is business, which CBG was not ordered by law to engage in as of 1st August 2018. Is this authentic, Honorable Nominee? Is this authentic?
Yes, it is, but just like the earlier opinions of the Attorney General that I alluded to. And indeed, as is apparent on the face of the letter considered preliminary observations and comments. I believe that was the title, preliminary observations and comments. Yes, and that was replied to by the Bank of Ghana later on, because the Minister for Finance drew their attention of Bank of Ghana to this, and they provided explanations. And subsequent to that, the position of the Attorney General is contained in a defense to the action that we filed in court. And it will interest you to know that after the defense was filed, the Attorney General initially emerged victorious because the matter, after being referred to arbitration, our defense at the arbitration hearing was appealed. Bank of Ghana did not file a defense, but we filed a defense. The defense was appealed by the arbitrator, and the matter was struck out by the arbitrator. Subsequently, the defendants in the matter, Dr. Dufo and Co., I'm aware, instituted a fresh action, and that action is both a subject matter of arbitration and a subject matter of a court of appeal matter. So I think that I would reserve further comment on the matter.
On that note, first you are wronged, and then you are wrong-footed. The process and procedures for getting justice are all smoke and mirrors. I thank you, Mr. Chairman.
Okay.
I thank you, Mr. Chairman.
Can you put yours off as well? All right. Is Gazella, because she hasn't spoken today, I'll give Gazella before I come to you. Yeah.
Thank you very much, Mr. Chair. Honorable nominee, what would you advise the President to be the limits of judges for the Supreme Court, assuming you were to be confirmed as Attorney General? Because, and what are the indices, if I may ask? Nigeria has a population of 206 million.
If you wish to stretch a little, I'll permit you to stretch for 5 minutes. I also want to use the washroom anyway, so.
Mr. Chair, do I suspend my question?
So when we come back, we'll resume.
Thank you, Mr. Chair. Nigeria has a population of 206 million. Apparently they have 16, and they will not take more than 21. Earlier on, you indicated that we don't really have a cap per se. We have a lower limit, but we don't really have an upper limit. We have a population of 31 million, approximately. What advice would you give the President on selecting the number of Supreme Court judges, and how many can the country take, or how many do we need?
Mr. Chairman, yes. Even though there is no cap or limit on the number of Supreme Court justices that may be appointed under the Constitution, there has been an observance of a convention to have 15 justices of the Supreme Court of Ghana at every point in time. Indeed, even though there are currently 16 Supreme Court justices, in about 3 months or so, it will be about 15, because one is due for retirement in a few months' time. So that
should be sufficient.
And I think that I'll observe the convention, 15.
My next question is just a little from your CV, and I'll move about a bit. There was a scandal on the board of PPA where you are an institutional rep. Now, with your legal mandate and with your legal mind, that assumes that you would have your antennas up for any, I assume, you'd have your antennas up for any mishappening on the board, right?
Yes.
But you also indicated that the sittings were usually around 10 a.m., and so you didn't have much time to attend. Am I right?
Yes.
Okay. So it is supposed to be the Attorney General or the rep. If you didn't have the time to sit at the meetings and pick up these signals as they were going on, you enjoyed the benefits, but you didn't have time for the responsibilities.
Mr. Chairman, I do not recall.
Talking about here, I'm not sure I'm getting the picture clear. Who is enjoying benefits and not taking the responsibility?
Mr. Chairman, I am alluding to his tenure on the board of the PPA. I think he understands where I'm coming from.
Very well, yeah.
Mr. Chairman, I do not recall absenting myself from not more than one board meeting. I attended every board meeting bar one during the 4-year period. The only meetings that I indicated an unavailability to attend were committee meetings. And usually committee meetings are held in the morning, and that's the time that Supreme Court hearings and Superior Court hearings are taking place. And for that matter, I was able to attend some of them. But the same holds for every Deputy Attorney General. I remember my predecessor, Dr. Dominic Aini, was a member of the PPA board. He was also a member of the PPA board, and the same held for him. It had never inhibited the Attorney General's ability from effectively offering the relevant legal advice needed for the work of the PPA.
See, so I'll just round it up. So you're going to be the leader of the bar, a leader of a very conservative profession. You may be on record as the youngest. Do you think you have the stature, the composure, and the presence to be the leader of the bar, considering that one of your hobbies on your CV is partying? You can read his CV, page 7.
Oh, yes. Mr. Chairman, I recall answering a major part of the question earlier on. I rely on my answer. Yes, as regards partying, indeed, I would indicate that since the happy entry into my life of the beautiful lady, Dr. Joyce assuming Dami, my wife, I have put brakes on that hobby. Occasionally, a party, but not regularly.
Put brakes. Okay. Well, your CV was signed 3rd February 21, and it's still there. So we don't know where the brakes were.
Occasionally, I party. But indeed, I mean, hardly will an Attorney General or a Deputy Attorney General have time for that. It's something that I care for.
Well, in your
but
hobbies,
the hobby that I regularly engage in is watching soccer.
Your hobbies didn't say occasionally. It was stated there very clearly.
The hobby that I don't miss is watching Liverpool.
You are stepping up to a higher office, so you are just reminded. So please be guided.
This is not a conversation, so allow him to answer. Then you come up with the next question, please. Are you done? Thank you very much. Yes, Honorable Nilante.
Mr. Chairman, thank you very much. Over 4 hours, I've heard the nominee talk about being fair to all manner of people. Let me just ask a simple question. As the Attorney General, who and foremost attracts your loyalty, if I would say? The President who appointed you, the party in power and government, or the Constitution and the people of Ghana?
Mr. Chairman, the Attorney General takes an oath of office, and the oath is the oath of minister to uphold and protect, preserve the laws of Ghana, and to defend him at all material times. So my first fidelity is to the preservation or protection of law and order in the country. Of course, in so doing, I am the principal legal advisor to the government. So I ensure that the government of Ghana will remain in compliance with the law at all material times. And indeed, it will also indicate you to note that the president, under Article 58, is supposed to ensure the maintenance of the laws of Ghana. So if my loyalty is to the president, that loyalty is to be exercised in accordance with the president's powers under Article 58, which is to ensure the maintenance of the laws of Ghana.
Yeah, so you accept the federal loyalty is the president. Is that what you're saying? That's what you said.
Chairman, I indicated that the Attorney General...
Please, let him answer. Let him answer.
Mr. Chairman, I indicated that the Attorney General takes the oath of a Minister of State. The oath of a Minister of State is set out at page 207 of the Constitution. And it says, the Minister of State shall uphold, preserve, and protect the Constitution of Ghana and all other laws. So the Attorney General takes an oath to protect, preserve, and defend the laws of Ghana. That is number one. That's the oath that I take. And I also take the oath of secrecy and the official oath as well. And I'm saying, Mr. President, apart from that, even, Mr. Chairman, apart from that, even if the honorable member were to construe the loyalty of the Attorney General to be loyalty to the President and the government, by force of Article 58 plus 1, the President is supposed to maintain the laws of Ghana. And therefore, yes, so that loyalty can only be expressed through that, ensuring that the President maintains the laws of Ghana.
Did you perchance have the opportunity of watching President Biden of America swear in the Attorney General, his new Attorney General?
Mr. Chairman, I did not.
Okay. I will just refer you to something he said.
And indeed, I'm sorry, the provision I referred to is 51 and clause 2, clause 51, 58, 1 and 2. I'm sorry.
I'm bringing this up because of the dilemma you face, even in the expression of loyalty, that one, to the Constitution and the people of Ghana, and also to loyalty of the President. President Biden said, "You won't work for me. You are not the lawyer for the President or the Vice President. Your loyalty is not to me. It is to the law, the Constitution, and to the people of this nation." I just want that to, because many a time your position is seen as, quote unquote, the attorney for the president. So it's always the case that you defending the president, the party people, and it doesn't make it seem as if there is fairness, there is justice for everyone. You are fair to everyone.
Honorable, well, I think you can answer, sir.
Mr. President, Mr. Chairman, the views of President Biden perhaps have been expressed differently, but they mean the same as what I said. It's the same thing. I said that the Attorney General takes an oath to uphold, protect, and defend the Constitution and the laws of Ghana. And then the Attorney General also, by way of offering legal advice to the President, is supposed to assist the President in the discharge of his executive powers of government in Article 58. And in Article 58, Clause 2, it stated the executive authority of Ghana shall extend to the execution and maintenance of this Constitution and all laws made under all continued in force by the Constitution. So the President has been given the mandate under the Constitution to maintain and defend the Constitution and the laws of Ghana. And the Attorney General is the President's legal advisor. That legal advice to the Attorney General can only be expressed within the confines of this provision to ensure that the President maintains and defends the laws of Ghana.
In your practice and objectively, in order to ensure that ordinary Ghanaians will feel that they also have some rights, they can enjoy some against people with power and authority. That if anyone in authority does something, I think that was principally the reason why we have the office of the Commissioner for Human Rights and Administrative Justice. What do you think we can do in order to make that office strong enough to make every Ghanaian feel protected going there to seek redress on issues that border on authority, government, power, when they are abused?
Mr. Chairman, indeed, the Commission on Human Rights and Administrative Justice is one of the agencies under the Ministry of Justice and the Office of the Attorney General. So we work hand in hand. And I think that it is important to place on record that I am a staunch believer in rule of law. I defend rule of law, and I've done so much of my life. And I've already even started having discussions with the commissioner, the Commissioner for Human Rights, Administrative Justice. And one major concern of theirs is the failure of this Honorable House to pass the Code of Conduct of Public Officers bill. And I indicated earlier on in my answers to the Japan transaction, the questions about the Japan transaction, that I think that serious inroads will be made into a preservation of human rights and ensuring that there's clarity in respect of what causes conflict of interest and what does not when it comes to interests of public officers in companies that they own before coming to office. And if that is a matter of serious concern for the Commission on Human Rights and Administrative Justice, I will work together with the Commissioner for Human Rights and Administrative Justice and ensure that this Honorable House, with your cooperation, passes into law the Code of Conduct of Public Officers Bill. Secondly, there is what we call the optional protocol on torture. Optional protocol is torture. And in that, a Commission on Human Rights in any country is supposed to be placed in the position of what we call a preventive mechanism of state. That is to ensure that it becomes the implementing authority for ensuring and curbing abuse of human rights and law. The Commission on Human Rights and Administrative Justice does not feel that it has been placed in such a position in this country, and indeed is concerned about measures that can be taken to ensure that comes about. If, by the grace of God, I get the approval of this Honorable House to be appointed Attorney General and Minister for Justice, I will work in that regard to ensure that these two major problems or two major concerns of the Commission are addressed.
Mr. Chairman, my last question. My last. You were Deputy Attorney General. Recently, there was a case involving shooting incidents in Odododio, for which, depending on the report you had, some people are being persecuted. You were in court once on that issue. Prosecuted. I want to ask, what sort of brief intel did you get in that particular case before those people allegedly being prosecuted were put before court?
Honorable Member, he has just explained that us at a time after Surgeon, he was no longer Attorney General, and he is still not. His office ended on the midnight of 6th January, and since he has not held that position. Which case are you referring to?
Mr. Chairman, I'm actually at a loss as to which case, which court, and which day that I was.
Criminal Court 2.
Mr. Chairman, sure, the last time I was in Criminal Court 2 was before the Christmas holidays. That was in respect of a contempt application against a person who had made comments on radio that the president had summoned 8 justices of the Supreme Court when such a thing had never occurred. And the person also made certain comments that he was going to burn the courthouse or something like that to that effect. I do not recall any other day, and I don't remember.
So am I taking it that you were not in court specifically for the Dodo case?
No, I don't, never. I've not been in court for that matter. I don't even know the matter you're talking about. Maybe it's being handled by the police. Who is the prosecutor? I'm sorry. That you may know the prosecutor for that case. Is it the Attorney General?
Honorable, you have to answer questions. You don't know. Let's leave it there. Now, whoa. I thought we agreed that we'll come to leadership. Yes.
Thank you very much, Mr. Chairman. Honorable nominee, in 2017, the Parliament of Ghana passed the Special Prosecutor's Office Bill into law, and the President consequently went on and appointed the first prosecutor in January 2018. So we'll say it's about 3 years now since we've had the office of the Special Prosecutor. If you are asked to give us an assessment of the performance of that office so far, what would you say? Thank you.
Mr. Chairman, yes, the Office of the Special Prosecutor constituted a very innovative mechanism in the history of the nation to fight corruption. And I think that effort must be commended. And I'm also aware of immense support that was given by the Office of the President to ensuring the success of the Office of the Special Prosecutor. I can make reference to the allocation of sums of 180 million Ghana cedis, I think last year, to the office. I can also make reference to the provision.
Nominee, Chairman, sir. Allocation of 180 million.
180, allocation.
Release or appropriation, because be careful, if you say 180 and you didn't get 180, you are under oath.
Allocation. The releases were pursuant to rules set out in the gift list as
so the Special Prosecutor Office got 180 million. Is that what you are suggesting?
Yes, allocation.
Thank you.
Allocation. And Mr. Chairman, I'm also aware of the allocation of, I think, about 8 or so story building to the office. And indeed, I have earlier on even indicated how the Office of Attorney General, attorneys there do not even have desk to write on. And I think that if an agency, also under the ministry, has such sufficient office accommodation, it's actually a feather in the cap of the president. The Chairman, I am unable to make any assessment of the work of the Special Prosecutor, because the Special Prosecutor under the law at 959 is supposed to be independent. Even though the Attorney General has ceded some of her procedural powers to the Special Prosecutor, the office is still independent, and we do not control the work of the Special Prosecutor. I am definitely aware of various concerns expressed by the public about a failure on the part of the Special Prosecutor to undertake prosecution, but that is clearly a matter within the remit of the office. The office is only accountable to its board, and it only presents, and it's supposed to file just report of cases they have done to the Attorney General. That's all.
Yes, Honorable.
Thank you very much, Mr. Chairman. I want to take the nominee back to the beginning. In the beginning, the nominee, in responding to questions about the Special Prosecutor's report on the risk of corruption in relation to the Ajapat deal, and particularly the issue of the agreement that was signed by the Deputy Minister for Finance, Charles Edubuahin. You addressed the question of the legality of the agreement that he signed, if you recall, in the beginning. And you took a legal position that the agreement is not one of those that should go to Parliament for approval, because following the decision in the Balkan case, it is not a major economic or commercial international transaction. That's a position that you took in your opinion. Now, you realize that the Balkan case, so my question really is a point of law. The Balkan case was dealing with a situation where a Ghanaian registered company signed a power purchase agreement with the government of Ghana. And the matter, a dispute arose, and the matter went to international arbitration. And the government of Ghana raised an objection that it had not received parliamentary ratification of the agreement, which was an international transaction. And the company argued that it was not an international commercial transaction. And the court, in analyzing that case, said that ordinarily a transaction involving the government of Ghana and a foreign partner, according to the Faro Atlantic case, is an international commercial transaction, which will require parliamentary approval. But in this case, the foreign element is not an entity registered outside Ghana. It's a company registered in Ghana, so it's a local company. And the effort was to find a way of establishing that even though it is not a company registered in Ghana, it will still qualify as an international commercial transaction because it is a major transaction in which several elements of the transaction have international implications, i.e., it is denominated in foreign currency, the shareholders are foreign, arbitration is foreign, and etc. So the principle in the Balkan case is not that, a transaction has to be a major international transaction for it to be international. The principle in the Balkan case is that where the party is a Ghanaian party entering into an agreement with the government of Ghana, and there's an effort to classify it as an international commercial transaction, then it has to be a major transaction. If that is the case, then the limitations that you seek to impose in relation to the agreement signed by the Deputy Finance Minister doesn't apply here. What applies really is the Faro Atlantic case, in which one party is a foreign party and the other party is the government of Ghana, and that is the basis on which the special prosecutor is saying that for such a transaction, you will need parliamentary ratification. What's your take on that?
Chairman, the true situation is that in Balkan Energy against the Attorney General, two major points of law were determined or decided by the Supreme Court. The first point was whether, as you said, the transaction qualified to be an international business or commercial transaction on account of the identity of the personalities behind the company in question. And the court held that on account of the fact that the company was controlled by external forces, it assumed an international character. So the court determined the issue whether a company is international, not just by looking at the location of the company, i.e. a company registered in Scotland or Netherlands or wherever. But the court indicated that in certain instances, the court will look beyond the company and look at the shareholding and the directorship. And for that matter, if a company is established to, even though registered in Ghana, be controlled by elements outside the country, i.e. the shareholding is foreign, the directorship is mainly foreign, the management is foreign, it will be deemed to be an international company, and therefore will qualify for Article 181, Clause 5. That is one. The second consideration was the decision by the court as regards the nature of transactions engaged in by international companies to warrant an approval by this honorable House. And the court said that it will be impractical for every international business or commercial transaction to receive parental approval. And they actually, in demonstration of that point, alluded to a situation whereby the government of Ghana buys air tickets. You buy air ticket from British Airways. Are you saying that by virtue of the fact that British Airways is a foreign company, anytime the government of Ghana is buying an air ticket for any of its public officers to travel abroad, that agreement ought to come before the Honorable Court? And the court said no. It is only major business. So the court imported into Article 1815 the word major. The court construed major to be the primary agreement. And I'm saying in this case, as the facts of the Balkan matter will show, it was a primary agreement which was the side matter of dispute. That is a power purchase agreement. The power purchase agreement was the main agreement, and for that matter required parliamentary approval. The appointment of a transaction advisor is not the main agreement at all, and can never be the main agreement. The Minister of Finance definitely would have entered into a transaction and then would require the services of a transaction advisor. So in line with the ratio or the rationale or the reasoning of the Supreme Court in that case, only the substantive or primary agreement of any transaction in question should be subjected to this honorable court, this honorable House for approval. But then subsidiary agreement which will only serve as incidental for satisfaction of the purposes of the agreement, need not be subjected to the requirement of prior parental approval. I think that's the point I made.
I'm holding a copy of the court's decision here. And the key issues before the court in the Balkan case, energy case, basically as formulated by the court, was the definition of international business transaction within the meaning of Article 181. Can a government of Ghana contract with a Ghanaian legal person or entity ever be an international business? Can a government of Ghana contract with a Ghanaian legal person or entity ever be an international business transaction? That was a major issue. If so, how are we to distinguish an international business transaction of a Ghanaian legal person from its other contracts with the government of Ghana? So the key issue, the key distinguishing fact in the Balkan case is the element of the other contracting party being a Ghanaian entity. That's a key issue in that case. So the court did not disturb the decision in Ferro Atlantic, which took a position that where the contract is with a foreign entity, a foreign resident legal person, that transaction is of necessary business transaction. say that because the legal entity is a Ghanaian company and then the investor is foreign arbitration and etc., it would be absurd to say that every other transaction of that company in Ghana is an international legal transaction. So the court was trying to now narrow it down and say, yes, we say that it is an international legal transaction, but then it's not every transaction of it that is an international legal transaction.
Mr. Chairman, no, I think, no, but it's a very important point.
Honorable nominee, what I see are two people seeking to interpret the same judgment from different angles. Can we move on and ask another question?
So the second element of the, what do you call it, the special prosecutor's piece that I think you should address is the position that he takes that the mandate agreement appointing Imara, South Africa, as transaction advisors, the subsequent appointment of service providers, brokerage providers, and etc., those ones, in his opinion, okay, given that the payment is to be done by the Ministry of Finance, he takes a position that they cannot be done outside the Public Procurement Act, and he takes exception to those transactions. What is your take on that?
Mr. Chairman, I would say that it is not uncommon for it, because the purpose for appointing a transaction advisor is to superintend a transaction, the process for executing a transaction. And by so doing, the transaction advisor may need a legal advisor, may need an accountant, may need some kind of service provider. So really, it is not uncommon in commercial law to have a transaction advisor appointing various persons. And I'm saying with all respect that the mandate agreement that was signed itself has expressly conferred on the transaction advisor the power to appoint various service providers. I think clause 2.21 of the mandate agreement says to identify and recommend to the MOF for appointment a list of other service providers and or underwriters that may be required to complete the transaction. So really, the appointment, if you look at it, is by the Minister of Finance. The transaction advisors were supposed to recommend and appoint, and that's really within the mandate. Otherwise, what will a transaction advisor be doing? Transaction advisor is supposed to superintend the process, and therefore that's it. I think that if one looks at the laws as a whole and gives a very purposive interpretation to it, you come to the conclusion that there was not so much untoward about the transaction.
My last question, please. My last question, outside the issues raised by the former special prosecutor, because I cannot put all my questions in that document. Something that has really worried me over the years. Commissions of inquiry. And I wanted to look at Article 280. If you can come along with me, Article 280, because it's a major issue that has come up consistently. I have seen commissions of inquiry appointed to inquire into some matters. And after what appears to be a faithful and impartial inquiry into the matter, they on their own proceed to make recommendations. They proceed to make recommendations. Now, if you look at Article 280, do you think Article 280 gives commissions of inquiry the mandate to make recommendations? Because my reading of Article 280 is that they are to inquire into facts and ascertain the facts and conclude on the facts. and leave government in a white paper to now make recommendations what it would do in relation to those facts. But time and again, I've seen attorney generals in enacting the instrument of appointment of the commissions put as their last, mandate, and to make recommendations. And then they also fall into that trap, and after finding the facts, proceed to make recommendations. Do you, in your reading of 280, think that commissions can make recommendations after finding facts?
I think the full remit of what a commission of inquiry, is supposed to do is set out in paragraphs A, B, and C of Article 280 clause 1. And I can see in clause B an implication into of the mandates there, the mandate to make recommendations. Right? It says to report in writing the results of the inquiry. If indeed the Commission of Inquiry comes up with a report and says that the results of our inquiry reviewed, systemic failures at, say, your constituency, I want to mention yes, Boku Municipal Assembly. And I think that it will be incidental, only incidental to such a function, to say that in order to cure the systemic failures, we are recommending A, B, and so. But that is why it is called recommendations. They're not binding on the government. Recommendations are recommendations. They just mean exactly what the word stands for. And the government can decide to disregard it if it feels so obliged.
Supplementary to that last
Thank
question.
you very much.
No, supplementary to that last question. Chairman, supplementary, you said we could have.
Thank you, you've had enough.
Supplementary, yes. No,
Honorable Chief Whip, now, we have a long run coming, so please. We've had how many hours? 5 hours now, and we're still running.
Thank you, Mr. Chairman. Mr. Chairman, I'm not a lawyer, as my colleague, the nominee, will know. But I was enjoying his interpretation to the Balkan ruling, where he was talking about the court and his views when the court talks about major agreement. Once it's not a major agreement, it doesn't require parliamentary approval, and is giving meaning to that. He is saying that major agreement means it's not driven from it's not the primary agreement. Is that right?
Precisely, that's all.
So you are saying that, in your understanding, or you are claiming that that is the court words, saying that major agreement means it's not a primary agreement, or you are giving that meaning to that?
Mr. Chairman, that was the position of the Supreme Court of Ghana.
Did they describe or define what they mean by major agreement?
Mr. Chairman, as far as I recall, that was so.
Can you refer us to that? Because where I'm concerned, they did not define major agreement. If you claim they do, I'll be happy for you to quote where the Supreme Court defined major agreement to mean.
No? No? Mr. Chairman, so you will see at page 1033 of the decision of the court as reported, 2012 Volume 2 Program Report at 99, that said on the other hand, the framers could not have intended the obvious and foreseeable paralysis from overload in Parliament that will ensue from interpreting the provision as covering every single business or economic transaction with an international dimension. The implication into Article 181 Clause 5 of the attribute of being major before a transaction enters into its ambit would does seem to be necessary and reasonable within the spirit of the Constitution. And then at page 1035, it says that examples, okay, so the defendant's hypothetical analysis shows a sample of many other transactions which could literally be brought into the semantic umbrella of an international business or foreign transaction, but which should not be so construed for the purpose of Article 181 Clause 5. Examples will be documentary letters of credit and for international sale of goods. The framers did not have in their contemplation subjectively or objectively transactions of ordinary commerce. Mr. Chairman, so clearly the Supreme Court even indicated that transactions of ordinary commerce, like documentary letters of credit, and the example that is stated there, should not be transferred.
So you agree with me that when you were saying that the merger agreement, you in your definition was not the primary agreement, was your interpretation, not what was the test. Because all these tests that you read, nowhere did it say that merger agreement means was is not the primary agreement.
It is so, because indeed in that case, they actually construed merger to be in reference to the agreement that was the subject matter of the dispute. And that agreement was the main power purchase agreement. They indicated so, that by virtue of it being the main power purchase agreement, it ought to be a merger agreement. And I'm saying that they went on in the part that I read to show that ordinary agreement.
Yeah, it was only examples that it was given.
Yes.
But it didn't say that once it's not a primary agreement, it's not a major agreement.
No, but the examples, I'm sorry, were a consequence to their holding that the power purchase agreement in question before the court, by virtue of it being the main agreement in issue, constituted a major transfer business or community transaction.
Well, in the case of the special prosecutor and his view, I tend to agree with him because I see that to be major. Because if you have a South African company that is going to be advising us in a commercial agreement that is virtually determining our natural resources, a chunk of it of as high as $750 million US. If anybody says that this is not major and therefore doesn't require parliamentary approval, I disagree. And I want to agree with the, what you call the special prosecutor. I mean, obviously, that's why we all have our opinion. And probably until the Supreme Court makes a definite determination on this, we could all continue the banter. But I can tell you that for somebody to be involved in such a quantum amount of money advising, obviously, that is major for me.
The mandate agreement was not worth $750 million. The extent, the highest extent, that is only in the event of success, was $4 million.
We are talking about
the main agreement, yes, was $750 million. I agree, and that is why it came to this honorable house. But the mandate agreement, the value of it, the payment under the mandate agreement, were only $15,000 a month. And I'm saying that the highest amount that could have been obtained after a success of the transaction was $4 million and nothing more.
I'm not talking about their charges. I'm talking about advising on the quantum of what they're advising. That's what I'm talking about, the 750, because that's what was involved. I'm not talking about what is going to them. I'm talking about what was at stake for them to advise. And if, for example...
if that is the case, then when the government of Ghana hires external lawyers to defend its interests in the matter, which has at stake $1 billion, by virtue of that, the hiring of a lawyer ought to be international business or community transaction. But we hire lawyers all the time. Since 1992, government of Ghana has hired lawyers for international arbitration. None of them has come before this honorable house, even though the lawyers that are hired are foreign lawyers. It is only our time, the last 4 years, that our international lawyers, our lawyers for international arbitration, were Ghanaian.
I don't dispute that. And it's like the example that you are giving, because some people have been doing something wrong and have not been bringing it, it makes it right. No, it doesn't necessarily make it right.
What I'm saying is that if this line of reasoning, is correct, then it would imply that merely because a lawyer is advising on a transaction worth $500 million abroad. By virtue of that, the appointment of the lawyer, apart from PPA approval, also ought to be a side matter of agreement. And I'm saying lawyers are hired by going to Ghana all the time abroad. And none of them, even though the lawyers are foreign, has had the agreement being a side matter.
And that's why I was telling you that if it's done, and I believe it's wrong, because if somebody is going to advise us on something that is worth $1 billion, the representative of the people need to know. Because if the person wrongly advises us, we could lose the $1 billion. So I'm looking at the what is at stake, not how much is paid that person. But anyway, in an earlier answer to your question, you claim that the special prosecutor did not give the parties hearing. Is that what you said?
Mr. Chairman, that is so.
But do you have on record, or you know for a fact, that he has given them an opportunity to write response to him?
Chairman, I have on record letters written requesting for documents to assist in an evaluation of the transaction by the special prosecutor. But there is nothing on record showing a grant of a hearing before the determination by the special prosecutor. And I think that if indeed you're evaluating documents and after your evaluation, you think that there are certain findings and you make comments and conclusions which border on wrongdoing against a specific public officer, it is only right that you grant the public officer a hearing before you go ahead and make those findings. That is an established rule of law and it's a fundamental human right. It cannot be done away with.
Mr. Chairman, I'm not a lawyer, but I want to believe that if there's an issue and you give me the opportunity to write, to explain myself,
no,
that's not hearing.
No, Mr. Chairman, there was no, that's the issue. There was no letter written by the special prosecutor asking A or B to respond to this issue or to say, explain why there was no parliamentary approval or why there was no PPA approval or why Charles Dubois signed. Definitely not. There was rather a request for documents, and that is not the same as the grant of a hearing. So the grant of a hearing must be construed substantively and not just.
Yeah, Mr. Chairman, in an earlier answer to a question, you also said that DataBank had been involved in transactions with the Ministry of Finance and government agencies, since President Kufuor's time. Is that right?
Mr. Chairman, since President Rawlings' time.
Okay,
right
since President Rawlings' time.
President Mills and Mohammed's time.
You said that. And you went ahead to say that during President Kufuor's time, they were involved in sovereign bonds, during Atamels, Mahama, and now. Did I hear you say that?
Mr. Chairman, I think that is the record.
Can you refer me to any of such transactions during the President Mills' time? Because between 2009 and 2012.
Mr. Chairman, I'm aware that that's actually contained in responses that were filed by the. In fact, so I think that it's at this point necessary to indicate that, Mr. Chairman, I am aware of a letter dated somewhere in January written by the special prosecutor, the acting special prosecutor, eliciting comments relating to events about the circumstances of the transaction. The transaction was the Japan transaction. And in that letter, the special prosecutor indicated that she was preparing to conduct a preliminary inquiry. So that even affirms the point I made earlier on, that there was no such grant of an opportunity. Then the Ministry of Finance, I'm aware that they wrote to the special prosecutor.
No, my question to you is with regards to data bank.
Yes, so I'm saying that that information, I'm sorry, that information was disclosed in the responses of the Ministry of Finance. That's how I came by the information.
And I know that between 2009 and 2012, I was in this house. There had never been the time where we had to resort to bond, a sovereign bond.
The Chairman, I'm not in a position to affirm the truth or otherwise of
but you said that
the official report. the Minister of Finance.
What I'm saying is that you have said here that Data Bank had been involved in financial transactions with the Minister of Finance during this period. And I'm saying that, tell us which transaction was this?
Mr. Chairman, I can produce to this honorable court, I'm sorry, Mr. Chairman, I can produce to this honorable committee a copy of the memo written by the Minister of Finance to the Special Prosecutor in January 2021. And that statement is contained in there.
So you finish this committee with that fact?
Mr. Chairman, I'm prepared to do so.
Are you aware the method that was used in procuring the services of Data Bank in the last 3 Eurobonds as a transaction advisor or book runners?
I'm aware of the method.
Of procuring, how they procure them, because you also sit on the board of Procurement Authority.
So,
was it through sourcing? Was it advertised? Was it through competitive bidding? What method did they use?
Mr. Chairman, I'm not aware. As I said, there are hundreds of transactions that unless, I mean, I do not keep records of it, I have no interest in any of them at all. The only transaction regarding the issuance of bonds that I am aware of is the first bond, a $2 billion that was issued by the Minister of Finance. And I'm aware of it, I remember the fact because it led to the report of the Commission of Inquiry, whether there was conflict of interest regarding the conduct of Mr. Kenneth Frater. And the Commission of Human Rights and Administrative Justice made a determination that there was no conflict of interest involved in the conduct of Mr. Kenneth Frater in that transaction. Subsequently, I had to file an action in court challenging aspects relating to the conduct of the Minister of Finance and Bank of Ghana, which bordered, actually, which instead of it, there was no grant of a hearing, and the court appealed it and quashed it. That's what I'm aware of.
So this very one that you are aware, the services of Data Bank, was it through competitive or sole sourcing?
The Chairman, service of Data Bank, I don't recall were used. I think that it was, the allegation was in relation to a person who was a director in Enterprise Insurance Company and was also a director.
That's FT. Is it not FT?
Pardon?
FT.
FT is what? Franklin Templeton.
Yeah.
Yes, so the person was a director in Franklin Templeton. So the honorable member is aware of all the facts. I don't think Data Bank was involved in that.
Okay. In the case of the 2013, Data Bank won to be the advisor to government in that sovereign bond through competitive bidding. That went through all the process and they won. But unfortunately, you say you are not aware of the processes that got them to be part of the other transactions.
And again, they won competitively. And I don't think that there has been any impugning of the role of Mr. Kenneth Frater as regards that transaction.
Mr. Chairman, the nominee is a board member of the PPA, right?
Mr. Chairman, yes.
How many other boards were you serving when you were the Deputy Attorney General?
Mr. Chairman, about 3, the Ministerial Advisory Board of the Ministry of Justice and Office of Attorney General, the Legal Services Board, again of the Ministry of Justice. And then there's another board which I'm happy that we brought up, I forgot, recently last year, the University of Ghana Medical Center Board. I'm also a member of the board.
So you are on about 4 boards, state boards.
Yes, you said how many other boards? I said 3 other boards.
What is basically your role as the representative of the Attorney General on this board?
The nature of my role as Attorney General on the PPA board. First is to, I'm sure the law anticipated that because really the matters that the Public Procurement Authority does are essentially legal. Approval of the various methods of procurement legal, ensuring an implementation of the PPA Act, ensuring compliance by various procurement entities with the PPA Act. These are legal. So I anticipate that's the reason why the law requires the Attorney General or its representative to be on the board. And conventionally, it has always been a Deputy Attorney General. my predecessor was a
So-
member.
so largely-
and I'm sure I will cease to be a member.
Sure, but so largely it is just to ensure that they comply with the laws.
And the
right?
Legal Service Board, as Deputy Attorney General, is required to be on the board. Same.
So how
as-
did you receive the investigative piece by Manasseh Awuni Azure on this contract for sale, knowing very well that you were on this board? How did you receive that piece of investigation?
Chairman, I answered the question earlier on, and I said that it was with surprise that I received it.
Did your board, did you know that his companies were involved in some of these things?
Chairman, the first time I ever heard of any company called Talent Discovery Limited was when Manasseh Awuni himself, as I indicated earlier on, called me and sought a meeting with me and told me about his own finding in the course of an interview that he had elicited of Mr. Ibieje.
Do you remember that the board secretary, that's the legal and board secretary of PPA, Mrs. Leslie Dodu, wrote to the SRAD claiming that, yes, he disclosed his interest to the board, and therefore he recused himself anytime his companies were before the board. Is this something that you can remember was on the board?
Chairman, I remember that, yes, the board secretary wrote that Mr. Ibieje recused himself in respect of one transaction, and that was the finding of charge as well.
And when he was recusing himself, what excuse did he give?
Chairman, I think the records will show that I was not even at that meeting. I stand for correction, but I think the ruling of charge indicates the persons who were present at the meeting. I don't think I was one of them.
Are you
But
telling?
reading the charge ruling, he indicated that he was a shareholder also, I think so.
Are you saying that that particular meeting you were not in attendance?
Chairman, I think that is what the charge ruling actually came up with. My name was mentioned as attending only one technical committee meeting. All the others, I was not there. I indicated that the technical committee meetings, most of the time, I'm not even there.
No, but unfortunately, the SRA report indicated that you were in the meeting, that this lady wrote to claim that he recused himself.
Then I'm very happy, because if indeed I was at the meeting that there was compliance with the law by Mr. J, then I'm very happy.
But you just said just a moment ago that you
Chairman, I said that I remember the SRA report said I was present at only one technical meeting. The number of meetings that I referred to, I think it was only one of them that I was present at.
My
The others, I was not
question
present.
is, you just said that you were never aware that he had companies. You just said that.
That's about hundreds, I told you, hundreds of applications.
No, it's not about the hundreds. It's about you sitting there and the CEO says that because this company I have interest, I'm recusing myself. But you have earlier said that you had never known that he had a company.
Chairman, as far as I did not record at all, because definitely that meeting, I'm sure, was 2017 or 2018. And Manasseh Awuni's work was in 2020. If the facts are right. It was about 2 years later, and I don't even remember. Chairman, it's only when one takes a personal interest in these matters that you will have all these things in your mind. And I had no personal interest.
But you know that it's the CEO that prepares and reviews all the tenders before it comes to the board. You know that that's how it works at PPA.
Yes, Mr. Chairman.
So recusing himself from the board meeting in Afghanistan doesn't take away the influence of insider trading and knowing what the quotations are in preparing the letters to the board. So recusing himself at only the board does not really exonerate him or take the burden of him having undue advantage and conflict of interest situation in there. So when he recuses himself and the board members, you think that that is enough, don't you think that it will not be fair to say that the board members are not culpable of the crime that he committed?
Precisely. Chairman, the 2 points. First and foremost, the duty to evaluate applications for research tendering or single sourcing applications rests with the board solely. The CEO only conducts an assessment of the compliance with the statutory documents. I mean, whether indeed some statutory documents have been furnished by the relevant applicants. So the CEO will determine whether the companies that have been shortlisted had sales net, had VAT. The actual consideration of the merits of the application is done by the board, and that's the board's duty. So, you know, and indeed, even that function of the CEO is only recently, is actually not in the law. So a CEO can just submit the application straight away to the board, for the board itself to determine whether each of the companies that have been shortlisted had statutory documents or not. And because, as I indicated, hundreds of applications come, clearly it would be onerous and unreasonable to expect a committee of the board sitting from, say, 10 to 12 or 10 to 2 to be evaluating all those documents to see whether the statutory documents are in order. So I think that first and foremost, the role of the CEO in this must be clearly understood. It is the board which actually carries out the function of determining the propriety of an application, and they do so. So, and secondly, charge itself determined whether there was compliance by the board or a violation by the board of any rule, and came to a determination that the issue was actually about Mr. ABJ. So I do not think that we can challenge
but I thought the SRAD had not said that, because currently the Ghana Integrity Initiative case, earlier you said it has to do with only asset declaration. No, that's just one of it. It also has to do with the board, and they are preparing a report on the board too.
Mr. Chairman, well, Mr. Chairman, if indeed that's the case, then I think that it will be prejudicial, this discussion about whether there is conflict of interest or a violation of a rule or a duty by the board, will be prejudicial to the work of SRAD.
Not necessarily. I mean, our orders are very clear. It's the chair who determines that.
Mr. Chairman, I am unable to comment on the matter which may potentially result in prejudice to the work of a constitutionally mandated body.
Mr. Chairman, in an earlier answer to a question answered by the nominee with regards to Unibank and the initial preliminary observations that he made, as he claimed that subsequent letters and explanation came and, virtually to say, negated some of his consent in those letters. But he will agree that the date for the establishment of the CBG and the date that it was given certificate, that you commented that giving them class 1 certificate to operate as a bank was wrong. That has nothing to do with...
Honorable, he has answered that question being read to him in full.
No, he said because they later provided better and better particulars, it made those consents virtually like irrelevant. But I'm saying that if you look at the date those things were, the bank was established, it's a fact that they breached the law. And I couldn't imagine any explanation that can undo that consent that you had.
All issues regarding the legal propriety of the incorporation of CBG are the subject matter of arbitration by Dr. Dufour and his directors. Again, all issues regarding the propriety of the decision of the High Court judge to refer the matter to arbitration are also pending in the Court of Appeal. And I do not think that it would be proper as a nominee for the position of Attorney General Minister for Justice to be making further comments on the matter. Otherwise, I'll be doing injustice, rather.
Mr. Chairman, earlier to a question on the Frontier Health Services Limited, he said because of the numerous documents that passes through PPA, I mean, he cannot recollect anything on that, right? But you've subsequently heard this being discussed extensively, I mean, in the public domain, and it keeps coming again and again the airport, what is happening at the airport, those who are there, they've not gone through the law, and the Deputy Attorney General, you are saying that you never took interest to know exactly what was happening there.
Mr. Chairman, to be honest with you, there are many aspects of the award of the contract for, is it testing for COVID-19 patients? Am I correct?
Yes, at the airport.
At the airport. Some relate to the price, no, that go on there. The very first time I actually took note of this particular issue was when the Minister for Health, the nominee for the Minister for Health, appeared before the House, and I heard that there was an issue of procurement about it. Apart from that, I have not heard that.
Mr. Chairman, I just want to find out from the nominee, in an answer to an earlier question on Gregory Afoko, you said that he couldn't meet his bail condition. Is that really what you said? He didn't meet the bail condition?
Yes, originally. And subsequently, there was a fresh charge of murder preferred against himself and the other accused person who had been arrested in Côte d'Ivoire. So the High Court judge in the second matter revoked the grant of bail, and the matter is still before court. It's a jury trial.
So you are now clarifying that he was later able to meet his bail condition?
That Chairman, I've not said that at all. I'm unaware of it.
Are you aware that he was able to meet his bail condition along the line there?
I'm unaware, and indeed I'm not surprised that I'm not aware, because we have two Deputy Attorney General. My remit was largely civil. That is why you did not find me in any of these criminal matters.
I want to find out from the nominee, who is your personal escort?
Chairman, my personal escort as in security provided by the state.
Yes.
Chairman, my escort has been provided by national security.
Is he a police officer or a military officer?
Chairman, at various times, there has been a revision of the security around me. In the early stages of my service in office, I even had no security. And subsequently, I was given a policeman. At another time, it was changed to a military officer. At another time, it was changed to a police officer. Well, Mr. Chairman, so the security that I get at every point in time is assessed. In fact,
I just asked whether he was a police officer or a military officer.
So, yes, until I can't discuss, well, until I was even going to say that at one point I even had no security at home. But I think that there has been a revision of that, and I don't want to disclose further details.
No, I mean, this is a public hearing. I'm asking you, the escort that you currently have, is he a military officer or a police officer?
Chairman, I think he has explained that sometimes it's police, sometimes it's military.
Mr. Chairman, I'm not talking about the sometimes. I'm talking about now. No, let him answer that. Let him say he's not in office.
Chairman, my security is revised every now and then, and without the greatest respect, I would want to.
It's a military officer that
no, I'm saying that especially at this material time. You remember that I made references to the past, in the past, because really those are matters of the past, and nothing can be done. But now, I think that in order not to, with all respect, and compromise any kind of security I have.
No, because you walk out now, everybody sees him with you. It's not a matter that is hidden. Neither my escort is hidden. Mine is a police officer. Yours is a military officer. And he's been with you for about 3 years.
Mr. Chairman, I remember that the Minister for National Security was asked questions on this line. Secondly, the Minister for Defense was also asked questions on this line. And I think that if indeed the House, with all respect, requires details of such matters, it can be elicited, but not on camera and before national television.
No, because our citizens are concerned about the militarization of our society. And
Honorable
you are one such person that
leader,
has a military officer.
Honorable leader, I think his personal security is being put into issue here. And I think it's safer to leave it here.
Mr. Chairman, it's not about his personal security. It's the one that the state is providing to him. Just as you and I, everybody sees us. When we walk out, everybody sees those who are foreigners.
Yes, for his personal security.
This is not something that he personally hides, Mr. Chairman. This is what the state is providing him.
Without due deference to you, I'm not saying he is paid or paying for them. I'm saying that his personal security now is being put into discussion, and I encourage you to move on.
Mr. Chairman, in an earlier answer to a question about the payment of compensation to the Iowa West Logan with regards to Emil Short's report, he also made an assertion that because the commission didn't determine the quantum, that has been the reason why payment has not been made. Is that right? Is that what I heard?
I said first that I was not the attorney general. I'm still not the attorney general, and there might have been reasons why that recommendation has not been implemented in the white paper signed by the attorney general. And I made reference to the fact that the civil liability law, I will examine the civil liability law and see whether those concerns that I anticipated to be the cause of the default in implementing the recommendations can be resorted to, and that I will endeavor to ensure that the conversation is worked out.
Well, when we were vetting both the defense minister and the national security minister, he created the impression that it's the attorney general's office that has to work with the finance ministry to resolve them.
Mr. Chairman, I heard that. Indeed, I heard that from the two.
Can we take your word that if you are approved to become the attorney general, this is something that you expedite action on?
Mr. Chairman, you have my word, and I'll do so promptly. Work with the finance minister and work out reasonable compensation.
Mr. Chairman, last but one, the road in the presidential transition team report, to be precise, report of the infrastructure subcommittee of the 2020 presidential transition team. Mr. Chairman, with your permission, page 19, paragraph 4.6, with respect to the Accra Intelligent Traffic Management Project. This is what the transition team report is saying on paragraph 4.6. Termination of the agreement between the Ministry of Roads and Highways, represented by the Department of Urban Roads, and the Beijing Everyway Traffic and Lightning Technology Company Limited for the Accra Intelligent Traffic Management Project. A contract was signed in 2018 for the project, and the two interim payment certificates has been raised, which are yet to be honored. However, through government policy, a new agreement for the same services was signed between the government of Ghana, represented by the Ministry of National Security, and Huawei Technology Company Limited, and the China National Import and Export Corporation. Are you aware that this company that the contract was taken away from is at the international arbitration seeking redress?
Mr. Chairman, the international arbitration never came to my attention before 6 January 2021. And I've also not received the handing over notes. I believe that if this Honorable House approves of my nomination, I'll receive the handing over notes, and then I'll take the due steps to ensure a resolution of whatever dispute there is.
Mr. Chairman, let me leave it here. Thank you very much.
Thank you. I'm skipping the minority leadership. I'm skipping you, or you want to ask? Yes.
Leonard, the general view is that you are doing well. And from a disco, perhaps if you had gone to St. Augustine, it would have been better. But that's okay. You'll get the next opportunity from your children to be there. Anyway, The banking sector cleanup, it cost this nation so much money. Billions were paid to investors who had lost their investment. Ghanaians are expectant that some investigation, some prosecution will take place, especially so when the view is that some of these investments were not properly done, as in the directors and the shareholders not having properly invested people's funds. And now government had to pay over 22 billion cedis, monies that could have been used for roads, improved healthcare service, improved infrastructure in our schools. So what assurance can you give to Ghanaians with regards to investigation and prosecution?
Mr. Chairman, I think that it is necessary to place on record that there are three major cases regarding the banking sector cleanup. The first is Republic versus William Atwesian and others. It involves charges for the offense of stealing. The second one, Republic versus Dr. Komna Dufour and others, charges of fraudulent breach of trust and dishonestly receiving. And Republic versus, that's the UT Bank one, Amabin or so, I'm sorry, involving offenses of fraudulent breach of trust and dishonestly receiving. The Chairman, I recognize that there's a need to, of course, as part of the efforts to ensure sanity in the banking sector and to ensure financial discipline generally, and take steps to punish offenses committed in relation to the banking sector. And that is the only way that we can boost investor confidence and protect investment and deposits of the general public. So I would take all the relevant steps as are necessary to ensure that we investigate any dockets that are available.
Can you also give assurances regarding asset tracing?
The Chairman, indeed, that's an area that is of serious interest to me, because I deplore the situation where the people commit either wrongs or crimes, and executing the judgment in relation to them becomes so difficult. I have had this situation, the Wyoming matter, for instance. I've been trying to trace the assets for the past 4 years. Fortunately, recently we were able to raise just about value properties, sell properties, the value of about 18 to 20 million. We are still tracking or tracing the assets. So indeed, our institute measures and strengthen the laws of Ghana to ensure that the investigative institutions of state are empowered to effectively trace and track assets of wrongdoers.
Leonard, if you have your constitution with you, Article 210(3), I read, the armed forces shall be equipped and maintained to perform their role of defense of Ghana, as well as such other functions for the development of Ghana as the president may determine. You know, in this discourse, our colleagues on the other side particularly have been raising issues, you know, seeing the military, and all that, even having to question why VVIPs or VIPs are given protection sometimes by the military, why some businesses or some installations have military presence. It appears that the reading of the function of the armed forces is often limited to the defense of Ghana. With the benefit of the full rendition or the provision under Article 210(3). Can you elaborate further of your understanding of the general role of the armed forces?
The letter, I think the letter of the provision speaks for itself, and it says clearly that the armed forces shall perform such functions as shall be equipped and maintained to perform their role of defense of Ghana, as well as such other functions for the involvement of Ghana as the President may determine. The President is the Commander-in-Chief of the Ghana Armed Forces, and for that matter has every right to, with all respect, determine the manner in which the armed forces operate, and that is clearly constitutionally expressed in Article 210, Clause 3. Further, I will refer to the National Security Council provisions, Article 83. Many a time people think that national security is actually some armed force organization. The national security is not an armed force organization. It has constitutional backing. It is set up by Article 83, and the committee will note that the National Security Council is made up of the entire armed forces plus other security agencies. So the Chief of Defense Staff is even a member of the National Security Council. The IGP is the Director General of the Prison Service, and the functions of the National Security Council in Article 84 will also show that they also have serious responsibilities for taking measures as are necessary to safeguard the internal and external security of Ghana.
So Council, from what you have just told us, I will be right in saying that anybody who limits the functions of our military, the armed forces, strictly to the functions of defending the territorial boundaries of Ghana, to be wrong. Anybody who thinks so is totally wrong.
That will be a narrow view of the constitutional provision.
Narrow view.
Narrow view of it.
Very well. Now, let us look at Article 1815. We've had a general interest in that area. Would you strongly recommend a legislation to further address the lacunae in aspects of the said provision? Because, for instance, my colleagues were having a banter with you regarding your view of the phrase major transaction.
Yes.
Don't you think that a legislation in that regard, as recommended in one of the cases by the Supreme Court, will help?
Mr. Chairman, that will be a positive step in the right direction. And it is actually on top.
Honorable Deputy Leader, if there's no issue to be clarified, I want to come to the leader so we can save time. We've done 5.5 hours already. Not running, and do one more and call it. You, I can bully you, not the others. I can.
As it pleases you. As it pleases you.
Chairman, so I will initiate such legislation. I think that it is high time that Article 181 Clause 4 be implemented by this Honorable House. Because the provision enjoins Parliament to enact an act of Parliament to provide for the particulars and the modalities for implementation of 181 Clause 5.
Mr. Chair, regarding Ejapa, Honorable nominee, the mandate agreement, which was between Imara and Ministry of Finance, did not include Data Bank as a transactional advisor. But in that agreement, there was a mandate given to Imara to further engage other advisors for the purposes of achieving its mandate. Is that correct?
Chairman, I think that is a little wrong because both Imara and Data Bank were engaged as transaction advisors from the parties, the formation. The agreement is made between Minister of Finance and Imara Corporate Finance Limited and Data Bank, together referred to as their transaction advisors. But of course, I agree with you in respect to the second part of the question, that they had been given a mandate, Imara had been given a mandate to engage other service providers.
Yes, and you had said that regarding that transactional advisory role, this is not the first time Data Bank has had to provide that services. I know that as a fact because I was here in 2015 when Honorable Setekwe was coming for Eurobonds. I was a member of the Finance Committee, and I know for a fact that Data Bank played diverse roles in that Eurobond transaction. I don't know of previous, but at least I know that during Mahama administration, that happened. Are you saying that the form and nature of that transactional advisory services provided then is same or similar to that which was required of Data Bank in this transaction?
Chairman, definitely the scope of the agreement may not be the same, but the essence and the substance are quite clear. That first, because the appointment of the transaction advisor did not constitute the main agreement, the legal position will be that it did not have to cite parental approval. Secondly, that it is not uncommon in international commerce to have a transaction advisor pre-giving the right to appoint or engage service providers, which will help in the attainment of the work that the transaction advisor is supposed to do.
So, in other words, it was Imara that brought in Data Bank as one of its advisors.
Yes, Imara, this will correspond to the rule of the tender process. The tender process required that bidders ought to come with local partners. And so the other bidder came with another local partner. So that rule, as I indicated, was not discriminatory. And there was no violation of any procurement law provision, as far as I'm aware.
Okay, so in rounding up, have a bite on this. Shraj investigated this ABAJ matter. Now, would you say that in their investigation, they didn't see the need to invite any of the board members, including you?
The Chairman, the entire board was invited, as I indicated. The board actually gave their comment, and I think the individual even wrote. Apart from that, the board chairman and two other members appeared personally to testify. That is why I make the very confident conclusion that if indeed there was wrongdoing on the part of any other board member, that would have been made out in the report.
So, Honorable Leader, I thought we agreed that you round it up so that we'll have saved some time. And it has not been the practice for the vices to be this long.
So would you say you've made some progress regarding management of judgment debts? I mean, not you as a Deputy Attorney General, but the Attorney General's department for the past 4 years.
Chairman, indeed, we have. And I can cite other instances apart from this Tony Woyome matter. There is the African Automobile against Accra Metropolitan Assembly and the Attorney General, which resulted in the state avoiding an amount of, will you believe it, about 153 billion Ghana cedis. The state also is currently in the Supreme Court challenging the payment to NDK Financial Services, a sum of about 1.5 billion Ghana cedis. And we have also avoided numerous judgment debts. They have all been made out, as far as I'm concerned, in a report.
Chairman, just for the record, when you mention 1.5 billion, tell us the purpose. What you are seeking to retrieve.
Mr. Chairman, because that matter emanated from the issuance of a security by the Minister of Energy, and it was just for the sum of about 263,000 Ghana cedis as a result of compound interest that was calculated on it. The company is currently claiming about 1.3 billion Ghana cedis from the government of Ghana, in spite of the government of Ghana having paid 79 million Ghana cedis. So we are in the Supreme Court. I myself argued the matter. I said that the money that the government of Ghana has paid, 79 million Ghana cedis, should be construed as full and final payment because it is inequitable and what have you.
Okay, Mr. Chair, finally, then I'll rest my case. PDS.
But there are other matters that I cannot recall.
On PDS, there are two issues I need you to clarify for me. You run us through the history of the transaction, MEDA, MCA, and that when the new government assumed office in 2017, nothing new was done except to create a new imbalance in favor of Ghana, that 51% ownership should go to Ghanaians.
As against 20%
yes.
early on.
Yes, and it was, you contended that you really didn't change the structure of the bid, whatever had been done, as to which companies participated. This government did not do anything new. Is that again your contention?
Yes, please.
And finally, on that PDS, isn't it the case that some third-party entity, other than agents or institutions of government, rather did some enhanced due diligence that resulted in this fraud, which was detected in Qatar?
No, that one was actually ECG itself, was the board and the CEO of ECG, which undertook to ascertain the authenticity of the demand guarantees that had been issued. And they kept writing to Output Insurance, and that culminated in a discovery of the wrongs that had been committed in the issuance of the demand guarantee. So it was actually an effort of ECG, and they must be commended.
All the public comments about supposed alleged corruption on the part of government were just misplaced and had no basis in law at all.
Such a man, there's actually no basis at all for any allegation of fraud of corruption to be made in this transaction. The facts are clear, as I indicated. It was the validity of the demand guarantee issued by PDS, and it was as a result of an inquiry by first ECG and the President's initiative in setting up a team to go to Qatar and to go to the United States of America, which established violations by PDS, and that resulted in termination. The Chairman, indeed, that's also a matter pending in court.
Chairman, thank you so much.
Honorable Minority Leader.
Mr. Speaker, thank you very much. I note that we have subjected the nominee to proper scrutiny as a committee, and I can appreciate that he's been sitting long with the family. But advisedly, because of Article 88 and the onerous burden, mandate, and authority of the Office of the Attorney General, let me just take you where my colleague left you. Do you have any evidence of a correspondence to PDS giving them any opportunity to have rectified the agreement per the contract with the power purchase agreement with ECG under the private sector participation? Was there any formal correspondence to PDS and an opportunity given them to rectify the demand guarantee?
Mr. Chairman, indeed I do, and I'm also
kindly submit that for our purposes. That's enough for me. And in respect of PDS, is there any claim by any affected party for judgment debts that you are aware of? Any action or claim for judgment debt by any of the parties affected following the suspension or termination of the transaction?
No, Mr. Chairman, I'm actually just aware of one case that has been filed by PDS against the Attorney General pending in the High Court.
Did the state of Ghana lose any money per the Millennium Challenge contract as a result of the handling and termination of the PDS agreement?
Mr. Chairman, I am unaware of such loss and rather aware of the saving of a national asset which was unsecured, consequent on the failing of the demand guarantee.
Would you say that before the government entered into that contractual relationship, there was trust in public officials who ought to have conducted due diligence to avoid what eventually happened in respect of a termination?
Oh, I think that, as I indicated earlier on from the timelines, the due diligence was actually conducted promptly after the demand guarantee was issued. The demand guarantee was issued on 27 February 2018. And
my simple question is, was that a failure of due diligence to have been conducted by public officials entrusted with public trust?
It will not be, because as I indicated, right after it was issued, the due diligence was conducted, and within about 2 or 3 months, the invalidity of the demand guarantee was ascertained. So there cannot be a failure of due diligence.
You serve on the PPA board. You've answered that. And you quoted a letter from the PPA and quoted extensively from Section 38A, reference to a letter by PPA. Did you take part in the meeting that eventually produced that letter?
Mr. Chairman, please, are you talking about the letter approving the Japa transaction?
Yes, you read that letter. And you referenced Section 38A, and went subsequent to refer to Section 39(1). And I asked you at that material time whether 39(1) was referred in the letter, and you said you were now speaking to it. Did you take part in the meeting, which eventually led to the approval letter as representative of the Attorney General on the board of the PPA?
Mr. Chairman, I would not remember, because really many meetings, as I indicated, I held, and I would not remember at all.
So you are on the board.
The provision is 38(1)A. Even though the letter wrote 38A, the provision should have been 38(1)A.
The Honorable Abdakwa, kindly give me your laws. The 38 doesn't have a 1, with all respect. Learned Deputy Attorney General. The Section 38 of Act 663 has no 1. It's just a 38ABC. So I have a copy here, and I'll share mine with you. And Chairman, may I request that he has a copy of the mandate agreement. I'd like to have your copy for my purposes. Section 38 doesn't have a 1.
Mr. Chairman, the
I
honorable
have
member
38A and B.
No, Mr. Chairman, the law has been amended, Mr. Chairman. And I think that you're not, this house amended the law. So there's now a Section 38(1) and a Section 38(2). And I have the consolidated version, because I'm a member of the PPA board. So you are misleading my very good friend. So, Mr. Chairman, that is why I said that the law was amended way back in 2016. It was amended in 2016 before this letter was written. So I have the current one, and I can give the House a copy.
Section 38, the Public Procurement Amendment Act 2016 Is there a further amendment to the 2016?
Mr. Chairman,
No, let him answer.
No, Mr. Chairman, it is the same one which incorporated a subsection 2. So the law, section 38 of Act 63, now has two provisions, section 38(1) and section 38(2). So, Mr. Chairman, I think that, and that was before, most importantly, that was before the letter was written. So I'm right in saying that the provisions have been 38(1). And I have the
Section 38(1).
Yes, 38(1)(a). So I have the consolidated version.
Just read your act title. Is it Act 914? I have no difficulty conceding.
Yes.
I'm holding Act 914.
Yes.
I see a 38 in it. I don't see a 1. It has heading of parts 7 of Act 633 amended. So just share that with me to guide me. I have no difficulty conceding to you.
Right.
I have Act 914. Which act are you referring to? The number. Just give me your number, act number, as amended.
So Act 914, amended.
You are also referring to Act 914.
Yes, but the point I'm making is that Act 914 introduced an amendment which inserted a further subsection 2 into section 38. And therefore, section 38 of Act 63 should be construed to have two provisions.
I'm fine. You are Attorney General. You are privy to it. Give me the date of Gazette of the one you are holding. I have 12 May 2016. So just share yours with me.
The Chairman is a consolidated Act 63. And in it, you see that
I concede to you. You recall, I concede to you.
I'm very grateful.
You refer to Act Section 38(1).
Yes.
But further said that reference to 39(1) was not in the letter you referred to, which was issued by the PPA granting the approval. Is that right?
Yes, Mr. Chairman, that is right. And that is because Section 39 is a procedure.
Will you accept that that was failure on your part because you serve on the board? The board will have benefited and ought to have benefited from your advice on this matter. The board issues a letter, and today you are expressing an opinion different from the board to which you participated in this meeting.
Mr. Chairman, it is not a failure, and the same will be done today, because the approval is given under Section 38(1)(a). And then the procedure, after the approval has been given, is for the entity then to have recourse to
So simply, was there reference to Section 39(1) in the approval letter you referred to?
Mr. Chairman, there was not, and there ought not have been.
Thank you. That's sufficient for me. And then, Chairman, let me now refer the nominee to the Special Prosecutor Act. And I have known and worked with the Special Prosecutor who resigned, and I know he's a very meticulous person with demonstrable fidelity to the law and patriotism to the country. Go to the mandate. Under Section 4(2), subject to Clause 4 of Article 88 of the Constitution, the office shall, for the purpose of this Act, be authorized by the Attorney General to initiate and conduct the prosecution of corruption and corruption-related offenses. Section 4(2)(1). So if you say that the Honorable Special Prosecutor could have just proceeded to court to prosecute, do you appreciate the provisions of Section 4(2) of the Special Prosecutor Act, in fairness to the Special Prosecutor?
Mr. Chairman, I appreciate it. And indeed, pursuant to Section 4(2), the Special Prosecutor has had full authority to prosecute for corruption.
Did the Attorney General on this specific matter give him the authorization to proceed to prosecute this matter?
Mr.
That
Chairman,
you have official correspondence on.
The Special Prosecutor has been given authorization to institute charges for corruption. And indeed, it has exercised that power in numerous cases. The Special Prosecutor himself, in the report in question, alluded to the prosecution of the Boko Municipal Chief Executive Officer. That is pursuant to Section 442. So
no, I'm just saying, you said you had difficulty with he writing to the president and that he could have just taken the initiative to prosecute.
Yes.
And I'm saying that his power to prosecute is conditional respecting his mandate under Section 4 of Act 959 of 2017.
Mr. Chairman, he could not even just have prosecuted. He could have proceeded to first investigate before prosecuting, because there has not been any investigation at all. He himself indicated in his report that this report was not an investigation.
Secondly, that's appreciated. That's appreciated.
That's I think very important. Even if Section 42 is construed to mean that the Attorney General ought to give authorization for each case before the prosecutor will prosecute, there has not been any investigation at all. There has not been docket built. And there had also not been any request for such authorization by the special prosecutor.
That's appreciated. Now on your ruling, I note that you've dealt with the matter sufficiently. Mandate agreement, I need your copy. The clerk, if you can help me have it. But first of all, it's important you appreciate, and you read it, that the Office of the Special Prosecutor conducted report on the analysis of the risk of corruption and anti-corruption risk assessment of the processes leading up to the request for approval and approval of the transaction agreement and tax exemptions granted by Parliament thereunder in relation to the gold royalties monetization transaction under the Minerals Income Investment Act 2018. You sought to trivialize the work of the special prosecutor by just referring to a mandate agreement and referring to Article 1815 and the judgment of the Supreme Court, and seeking to make a distinction between ordinary commerce and what you describe as non-major international economic transaction. Was the Ajapa royalties transaction international, in your view?
By referring to the, Mr. Chairman, I think that first I must also correct the impression conveyed by the question that I sought to trivialize the work. I did not say so at all. I did not trivialize the work of the special prosecutor. I actually indicated that I would even construe Section 2C to import a mandate to conduct such an exercise. And it is good. But the purpose of conducting this assessment is to guide future actions, which is futuristic. And that is why I said, well, now.
So will you describe a transaction of debt financing, monetization of mineral royalties of Ghana to an amount of $500 million to 750 million US dollars as major or minor? What would be your classification of the transaction?
I believe that by referring to that transaction, you're referring to a mineral royalties investment agreement, the main agreement itself. That's an international agreement.
What was the purpose of the mandate agreement? Was it not pursuant to the master agreement, which was debt financing of monetization of $500 million US dollars? Was the mandate agreement working alone?
No, the mandate agreement clearly, as you indicated, is even implied from your question that it is subsidiary to the main agreement.
So is there a relationship between the mandate agreement and the Ajapa royalties transaction, which was seeking to monetize our mineral royalties for $500 million to 750 million US dollars? Any relationship?
The relationship is that the mandate agreement was only supposed to recruit a financial advisor to advise on the execution of the mineral royalties agreement.
So in your view, is the mandate agreement which is minor?
It is subsidiary. I'm not saying it is minor.
No, you used a word earlier. Yes, is it the mandate agreement is minor, in your words?
I didn't say minor. I said I used certain words: major, primary, subsidiary, and all. So the major or primary agreement was the mineral royalties agreement. And then this mandate agreement was subsidiary to it. And clearly,
No, the minor, I'm borrowing from you because I listened to you. You even along the line, when responding to Honorable Muntaka, gave the example when you quoted, with respect, Justice Datiba, as I asked you, and you distinguished between ordinary commerce and major economic transaction. Ordinary commerce, you use the example of ticketing.
Yes.
Can we compare pitches of ticketing to monetizing our mineral royalties of up to 550 million?
Mr. Chairman, I think that we got it totally wrong. The agreement was not to engage a transaction advisor. I do not think the Minister of Finance just set out to say they are engaging a transaction advisor in the sum of 750 million. What would be the purpose? The transaction advisor was just to superintend the main agreement, which was what? The mineral royalties agreement. And in the quotation by that I made, the reference to Justice Datiba, it's not just ticketing that he alluded to. He alluded to such other transactions in the course of ordinary commerce, like letters of credit. So if indeed you enter into an agreement whereby a foreign bank is supposed to execute letters of credit on your behalf, are you going to say that that is a major international agreement? The court said no, and I construe this mandate agreement in the same vein.
Honorable nominee, I won't belabor it. You shared your opinion. I'm also just sharing my opinion. May I refer you to a letter you quoted and again captured in the Special Prosecutor Risk Assessment Report when you refer to a letter from the Ministry of Finance dated 6th October 2017, which was signed by Honorable Deputy Minister Charles Edubuahin. Now, if you refer to the Special Prosecutor, and this emphasis is mine, you mention some entities, Triple Flag, Navara Capital Limited, Stanbic Bank, in that lane. These were the words of the Special Prosecutor. The absence of the name of Imra Corporate Finance from this list needs to be noted. Now, Imra later on, the relationship of $4 million US. Is that also major or minor?
The appointment of Imara Corporate as a mandate agreement, I've stated time and again that it not constitute a major international agreement in the context of Article 181 clause 5.
You also
Mr. Chairman, I think that the omission of Imara Corporate Limited from the list that he indicated was really nothing remarkable, in the sense that the documents that were submitted, the application that was made to the PPA board, included Imara Corporate Limited.
My search reveals that as at October 2019, PDS, subsequent to the agreement government signed, was still in possession of some money of up to 3 billion Ghana cedis. Are you aware of it? And does the state have any resources to retrieve from PDS?
Mr. Chairman, I'm unaware. Mine is to deal with legal issues, and now I'm aware of a suit that has been filed by PDS against the Attorney General pending at the High Court of Accra.
While the agreement was pending, did PDS receive some money, and would you be interested in finding out what has happened to that money?
Mr. Chairman, that will be within the remit of Minister for Energy. I can see my very good friend, Mr. Doctor, Doctor waiting for his turn.
May I now refer you to the 1992 Constitution? There are those who think that some provisions of it should be amended, some think that there must be a holistic constitutional review. In your view, I heard you on Article 11(7), requiring some amendment. You should be aware that it's part of the entrenched provisions of the Constitution, and you know what is legally needful and appropriate to do. But which aspects of the 1992 Constitution would you want to see reviewed?
I think that the circumstances of our time will definitely require a consideration of Article 78(1). So I think that it should agitate the minds of Ghanaians whether still find Article 78 plus 1 relevant. I would recommend, even though it's again an entrenched provision, an amendment of Article 78(1) to remove the requirement on the president to appoint majority and the emphasis on majority of ministers from parliament. I think that the president may appoint from parliament and he should be given a free hand. That is one major provision that I would think that the people of Ghana, apart from me, would require urgent amendment.
Thank you. May I also refer you to Article 131 of the 1992 Constitution and just seek your view on a particular matter. It reads, an appeal shall lie from a judgment of the Court of Appeal to the Supreme Court. And the opening words in 131A says, as of right, in civil or criminal cause, or matter in respect of which an appeal has been brought to the Court of Appeal. Do you think that it must be an appeal as of right?
I think that, Mr. Chairman, well, as of right, it could still be there. I think so. But the Supreme Court should have the power and should be able to exercise it effectively of managing appeals that they hear. Because the situation where the Supreme Court is flooded by so many cases, you go to court every day, and it's almost like the first court in the Superior Court architecture. It's not right. I think the Supreme Court should hear only serious matters, and the court should be able to vet the appeals and other constitutional matters that they consider.
What will you do to improve relationship in enhancing the performance of the bar to facilitate the administration and speedy delivery of justice in Ghana when approved as Minister for Justice and Attorney General?
Mr. Chairman, first, I think that lawyers ought to be candid. We have had an inundation of the Supreme Court with so many cases, Court of Appeal also with so many cases, because lawyers sometimes unjustifiably refuse to accept the outcome of cases that are adjudicated against them. I mean, when I was in private law practice, I could count the number of appeals that I filed. Of course, with all respect and all humility, most of the time I succeeded because I pursued the right courses. But in cases, rare cases, that decisions went against me. It is only when I felt very much aggrieved or very justifiably aggrieved that I will pursue an appeal on behalf of my client. So to start with, lawyers ought to be candid. Even simple tenancy matters, they will appeal against the
Honorable
I think that's wrong.
nominee, we're asking what you will do. We want the lawyers, you will be the leader of the bar, so we'll deal with them, but how can you assist the speedy recovery of justice?
So Mr. Chairman, I think that in line with that, perhaps continuing legal education ought to be enhanced, ought to be boosted. So I will support the efforts of the bar to ensure continuing legal education. I will also support I think now, lest I forget, earlier on in my response to the question about the Ghana Law School, I omitted the fact that the Ghana Bar Association itself has actually contributed an amount of money for the undertaking of the Law Village project. So the Law Village project is about to start. The drawings have been accepted, and the Ghana Bar Association has taken the lead by contributing a very significant amount of money. So, Mr. Chairman, I will join hands with the bar president to ensure that all that is required to boost the performance of lawyers in Ghana will be done.
Thank you, Chairman.
I'm happy that the bar president is here to support me today.
Thank you, Chairman. In your answer, when you referred to the Balkan Pharaoh Atlantis case and others, you emphasized heavily on Article 181(5) of the Constitution before sharing your opinion. For emphasis, let me, with the indulgence of Chairman, read. This article shall, with the necessary modifications by Parliament, apply to an international business or economic transaction to which the government is a party as it applies to a loan. We have accused over this as Parliament, not just this Parliament. The executive have accused over this because I'm not aware of any modification. So beyond the Supreme Court ruling, what is your assurance that when you become Attorney General, you will give true meaning to the letter and spirit as expressed in Article 1815 of the Constitution?
Indeed, I said that it's a matter that I've considered for a very long time now, and it's something that's dear to me. I think I will really initiate legislation to give meaning to Article 181 Clause 4, which requires an act of Parliament to be passed. Because really, the business community will stand to benefit from such an act of Parliament. The business community ought to determine, ought to be able to know which transactions ought to come before this Honorable House and which transactions ought not to come. Maybe a time, international arbitrations are even fought on those lines. The government of Ghana, when it wants to resign from contracts, will then set up a defense. Oh, these agreements have gone to Parliament. And then it becomes a matter for international arbitration. I think that we ought to enact such an act of Parliament.
So the mandate agreement and the Japan monetized agreement, by your standing, does it qualify to be an international economic transaction?
I've answered this question many times, and I will repeat that the original agreement, the gold royalties agreement, was an international business agreement and should have come before this House, and indeed it came before this House and was approved by this.
But the mandate agreement.
But the mandate agreement, I think that in international commerce, it ought not to have come, and it has not come.
Okay, that's your view. So you sought to dissociate yourself from your boss, the Honorable Gloria Akufu, on her opinion so expressed in those 3 letters that you referred to. Is that right?
No, Mr. Chairman, I did not. I said I stood by all the letters that
you said that,
and she never gave an opinion.
You said that she was not opposed to Ejapa. Should we expect Ejapa back? And in what form, character, and nature?
Mr. Chairman, that's the duty of the Minister for Finance. The Attorney General does not generate international economic transactions. We don't engage in that. We appoint our lawyers abroad to fight for the government of Ghana. That is all.
Chairman, I'm almost done.
I was going to announce
we want to
that
request that
you're done.
No, all the documents he referred to, he should table them. Especially the mandate agreement. As Chairman, I requested that I wanted to make reference to it.
If all questions are exhausted, I can give the mandate agreements now.
Yeah, I needed it.
If your questions are
No,
exhausted,
but that, Chairman, I requested that I wanted to make reference to it.
Oh, okay.
Clerk, I did. You were here.
No, that's
So I
this is my only copy. I'm giving it to you. But I can give it to you if you are not asking any further questions. But this is my only copy.
And then finally, Chairman, we'll spend enormous time with you. Mine is Podo versus Attorney General. You recall that on the District Assembly Common Fund, the Honorable Podo and Richard Koshiga filed some matter regarding the District Assembly Common Fund and its percentage. Ruling has been given. Do we have your assurance at Attorney? No, I just want to use it once before the copy. Do we have your assurance that you work with the Ministry of Finance to ensure that the ruling of the Supreme Court is respected in its entirety in ensuring that what truly is the deserving revenue of the Common Fund will be attributed to the District Assembly Common Fund?
Whatever you do.
And then just in the news yesterday, everybody read data bank withdraws from a Japa deal. It was not data bank withdraws from a mandate agreement deal. So it tells you what role data bank probably played or was playing as book runners in the transaction. Now, in the mandate agreement, you've just given me a copy. This is the title. entered into by Ministry of Finance of the Republic of Ghana. Then it has IMRA Corporate Finance Limited. Then it has Data Bank Financial Services Limited. So, Chairman, I just want our records to capture it. This is the mandate agreement.
He has said
no.
all that already.
Oh,
he himself repeated them, all of them.
Yes, I know. I'm referring to it now. And I'm just establishing that there is some reference to it to the Ministry of Finance representing the government of Ghana and to IMRA Corporate Finance Limited. And in his view, this does not qualify as an international economic transaction by the provisions of Article 1815 of the Constitution.
I guess that's the end for the minority leader, the ranking member.
Yes, Chairman, but
thank you. Thank you very much. After 6.5 hours, I have the Honorable Deputy Attorney General nominee.
Yes, sir.
There are some petitions brought to this committee. I've read them. None of them is alleging any specific misconduct on you. By you. One is by one Madame Frida Daku. She's saying that you did a case against her husband, but you tried to execute against her account. Why did you do that?
I think quickly, I will just indicate that the case...
Kindly be brief. We'll give you 6.5 hours of our time today, so make them short, crispy.
I'll make it very brief, and I'll quickly indicate that the case I did, or the cases I did, were actually against both Madame Frida Daku and her husband. Indeed, my client, the late Lene E.T. Kwashi, had gifted a piece of land to his wife. The land is at East Legon, and the land was trespassed upon by Madame Frida Daku's husband. So my client's wife, a rate was taken out in her name. The case is Comfort Kokokwashi versus Yaomenu. The judgment was given on 2209, 2nd July 2009. I have a copy of the judgment I can give to the committee. The committee will note that the judgment was entered in favor of my client after trial, and damages in the sum of 50,000 Ghana cedis 2009 were awarded. The chairman, after that, the defendant judgment debtor sought to set aside a judgment, and by another ruling dated 14 May 2010, the High Court dismissed the application. I have a copy of the judgment of the ruling. I can give it to the committee as well. Subsequently, we went into execution. I think even before we went to execution, they made another application. Chairman, so we went to execution, and the judgment, the certain accounts were attached. And Ghana State, the Chairman, Madame Frida Daku indicated that her account has been erroneously attached. Indeed, the record will show that when she made this claim, I never disputed it at all. So the court actually gave a ruling dated 11 November 2010, releasing the account from attachment. And it's very important because the complaint seeks to suggest that I strenuously sought to attach the account and afford and all that. It says here that speaking to a motion or notice for sale of execution, counsel for defendant applicant stated that plaintiff respondent has been served. He referred to a motion paper and the position in support, stated that the wife of defendant was not part of the suit and is wrong to attempt to garnish her account, and that there is no judgment, so. The fact says the motion has not been contested. So the record will show that when this was brought to attention of the court, that her account has been attached, there was no contest at all. In all fairness to my practice, as I always say, I didn't contest. Can I say proceedings are maintainable in respect to a judgment debtor, and therefore, in the absence of any contest, it was released. Chairman, that is the ruling of the court dated 11 November
Very well.
2010.
I brought this
but interestingly, Madam Fidadapo, after this, then filed a case indicating that she owned the land, the same land that we had won judgment to respect thereof. And the High Court on 7th March 2013 was a raised an objection and all. Madam Fidadapo filed an application for executory injunction. In opposition to the application for injunction, I raised an objection to propriety of the suit. The objection was dismissed. The court stated, in suit number so, the plaintiff in this suit was not a party, but rather her husband was. If the plaintiff wants to set aside a judgment on grounds of fraud, then she should have done so in the name of her husband with his permission, or she should have sued the parties in that suit. Chairman, the court then finally dismissed Madam Fidadapo's. It says, in this case, the plaintiff has made some admissions above referred to and was not a party to the judgment letter that she wants the court to set aside. Without coming by this new method of setting aside the judgment, in her capacity as a person affected by judgment, I will not only refuse the application for executory injunction, but will also dismiss her action as an abuse of legal process. So Madam Fidadapo's action was dismissed again.
I brought the case and I said that there is no misconduct on your part.
Yes.
But there's a reason I brought it up.
Yes.
Because I want to announce that there are so many alleged petitions before us, yes, which are not alleging misconduct on the part of the nominees, but rather people have issues they probably think that, yes, this committee has the power to. There are some by trade unions, some by other people's employees who have issues with them. Those are private matters. So I'm putting it on record that I brought it up so that I'll get the opportunity to speak to that matter. But there's another one. So the same, they didn't say anything, but it's of public interest. Men's Gold aggrieved customers. They say you didn't take any action against Nana, what Nana Mensah, is that his name? Why, as Deputy Attorney General, you didn't take action against Nana Mensah?
Chairman, I was not the Attorney General, and indeed, I don't recall ever handling any matter about Men's Gold when I was there. There's reference to a petition was never addressed to me. There were two Deputy Attorney General. The other Deputy Attorney General, I remember, rather was assigned a brief respect of Men's Gold and actually went to Dubai in connection with it. So perhaps it's a case of mistaken identity. It could not be me. But
thank you. I think
again,
it's enough.
About Madam Fidadapo, it's a matter that is of concern. She has been peddling a lot of falsehood even before she came to this committee. Who? The records will show Madam Fidadapo. The records will show that she lost.
You're doing the same thing.
Yeah.
You have a problem with her elsewhere.
I'm just going to show that she lost both at the High Court and the Court of Appeal.
That's
and
okay.
Came back to the High Court again. And
I know you're capable of defending yourself elsewhere.
So the records are there.
Chairman, I just needed to, on a matter, I concede to him, but the Public Procurement Amendment Act 2016, Act 914, that I referred to and I'm holding, indeed, under Section 17, and it reads, Section 38 of Act 633 amended. Therefore, I have a difficulty accepting that I'm referring to a wrong act, because in that it provides.
That's not like it. You're not saying you're referring to a wrong act.
Okay, I appreciate that. So My very last, but I just wanted to put that on record because the 38 here is not in tandem with what you have as consolidated. But just in an answer to a question to Honorable Sohine, the 35 other mining leases to which the Honorable Nogbe and others have instituted action at the Supreme Court, you indicated that they have not been ratified by Parliament. And stretching the Ndaburi decision, what steps will you take as Attorney General to control and stop the illegal mining of our resources by those entities that have not been ratified by Parliament? I thank you, Chair.
That's why I earlier indicated that I'm not aware of the specific circumstances of the various leases that were referred to. I know that the suit that was filed by my very good friend had various constitutional issues, and we raised objections to it, and the matter is pending before the Supreme Court.
Thank you for enduring us, for attending upon the committee. You are discharged. You will hear from us.
Everyone, very grateful. In the past, they would acknowledge family members, there were people from Wenchi and all that. I do not see that at this time. Is it a departure from the norm? Thank you very much.